Alright, hi everyone. I think we're going to go ahead and get started. I know people are still trickling in and going through security, but we don't want to cut the program short. My name is Morgan Suter. I'm the Vice President of Legal Education for the Federal Bar Association, the San Diego chapter, and welcome to our annual Introduction to Litigation in Federal Court program. We're thrilled to have all of you here. Before I introduce our first speaker, I want to go through a few housekeeping matters. First, there will be a 20-minute break between panels at 2:45, and coffee and cookies will be available on this patio out here. So please stretch, get up, enjoy a little break. And then there will also be a reception from 4:30 to 5:15, and there will be light refreshments and drinks, including wine and beer. So we hope all of you can stay and enjoy the reception following the program. In addition to this annual program, the San Diego chapter of the FBA hosts a number of events throughout the year, and I wanted to mention a few of them, so hopefully you can join us for those as well. We are hosting a 4-part panel series on disclosure and discovery in the Southern District. The first session already took place last month, but the remaining 3 sessions will take place over the next 3 months. The remaining panels are on written discovery, deposition practice, and working with expert witnesses. The FBA is also hosting an Equality in the Law conference on August 16th, 2018. It's going to commemorate the 150th anniversary of the ratification of the 14th Amendment. The conference will discuss the evolution and history of the Equal Protection Clause, where it started, where it is now, and where it is going. We have an impressive and dynamic group of panelists lined up, and it's an event we don't think you'll want to miss. Additionally, the 14th Annual Judith and Keep Federal Civil Practice Seminar will take place on September 5th. This year's program will be on trial practice, and it's a popular event every year, and we're looking forward to this event as well. Lastly, if you're not already an FBA member, please consider joining. There are applications on the table out front, or feel free to ask me or anyone with this blue name badge, and we can give you more information about being an FBA member. Now, on to the reason we're here today. It is my absolute pleasure to introduce to you Jim Wagstaffe. He is a partner and co-founder of San Francisco-based Curran Wagstaffe LLP, where he handles a diverse range of litigation matters and also leads the firm's highly successful federal practice group. His practice focuses on complex litigation, professional and governmental representation, legal ethics, and First Amendment matters. Complementing his vast courtroom experience, Mr. Wagstaffe has authored a number of publications, including the widely used Federal Civil Procedure Before Trial, which is a 3-volume publication considered the nation's leading practice guide on federal court practice. Mr. Wagstaffe is recognized nationally as the authority on federal civil procedure matters, and we are very lucky to have him here today to speak about federal jurisdiction and venue. Thank you.
That's just fabulous. A national leading authority. That's as good as it is. Although I said earlier today, a client who hired me a couple of years ago, 1 week after I was retained, saw an article about me in the newspaper and said, "Your reputation exceeds you," which I thought was true enough. All right, we're doing the best we can. Hey, see that guy up there? So I wrote this book published by the LexisNexis on federal practice, a page-turning book and now online. And they said, you need to have an avatar, so I got one. There it is, that's me up there, although my 2 grandkids say I look like Papa Smurf, so I don't have much credibility. So I said, look at the title of the program, Finding the Ripcords. Let's figure out why I got that. No, see, the angel says to the parachutist at the gates of heaven, this is your ripcord. That's just a loose thread. Knowing the difference between ripcords and loose threads, particularly in federal court, is the answer for approaching litigation. Ripcords and loose threads. So there are resources available to you. You have a handout of an outline that I think they gave to you, which is an outline of home run motions, and in particular checklists on jurisdiction. Some things I'll be talking about today. Got some PowerPoint slides. I'm sure the FBA can help you get those. And if you really love jurisdiction, I have also a thing you can get online on the updates of jurisdiction in the last year, some of which we'll talk about now. So that kind of gets us started. Let's start with this simple proposition, which is that Will Rogers said, if you want to make a fire with 2 sticks, the best thing is to have one of them be a match. That's the whole deal on litigation, and particularly in federal court, is getting it right. So let's start with a simple #1 case of civil procedure history. If you're getting a crick in your neck, it reminds you of law school and the bar exam, God forbid, it's Erie Railroad versus Tompkins. We know Harry Tompkins' picture was taken here before the accident occurred because he still has his right arm, which was lost in the accident from the train. All right, so you know the basic rule. And you'll see why I'm starting with this on federal practice. If we have a state claim in federal court, that is a diversity claim or a supplemental jurisdiction claim, we're going to apply state substantive law. But we're going to apply federal procedure. Therefore, the differences in a case in state court and federal court on its surface will be the difference in procedures that apply. So Erie tells us we're going to have equality. The 150th anniversary of the Equal Protection Clause. If you're a nerd like I am, you know that Erie actually was not directly an equal protection case because it hadn't been applied in that regard. But nevertheless, egalitarianism was. And I am a nerd. I admit it. I met my wife in law school while she was reading Penoyer versus Mel. That's as good as it gets. Forget Match.com and eHarmony and Tinder and Bumble. This is the answer. Therefore, since we're in federal court, we've got to say, what are the differences? I teach civil procedure, federal and state, 2 different courses in my law school. It's not only the bar exam, as you know, but there's differences. This screen tells us the differences, the vast difference there are in procedure between state and federal court. Different rules of jurisdiction, of course, because federal courts are courts of limited jurisdiction. And Twombly-Iqbal's in federal court and not in state court. And discovery, we have disclosure in federal court. We don't have them mandatory in state court. Summary judgment, Celotex is big in federal court and not as big in state court. And all different rules of venue and juries and judges. So it's different. So let's do some learning. So we got to figure out, therefore, when does it make a difference? Sometimes they're easy. How many pages is the brief? Procedural rule, right? Sometimes clearly substantive. What are the elements of the cause of action? Substantive. But it gets a little tricky, as it has, when we have state reform examples. So California has passed many tort reform statutes. Damage caps in certain areas, and micro for malpractice cases. Many cases you have to give pre-lawsuit notice before you can speak or you can sue. You get an automatic right to bifurcate punitive damages for purposes of net worth in state court. In many causes of action, you have to have a certificate of merit before you file it, say a malpractice action. Do any of those procedures apply in federal court? Or are they procedures at all, or are they substantive? That's the real question. Because if they're substantive, we've got to apply the state rule. So what we've got, let's take an example. California has an anti-SLAPP statute. The California anti-SLAPP statute applies in federal court insofar as you can bring a suit when someone is suing your client for a motion, suing your client for something that arises out of the First Amendment rights, right? And you can move to strike it. It's a big statute in California, 425.16. The Ninth Circuit has held that the right to bring such a motion and the right to get attorney's fees and get an immediate appeal applies in federal court on a state law cause of action. And another circuit has gone away. Another 2 circuits have held no. We're federal court. You can't tell us how to do our dispositive motions. We've got Rule 8 and 9 and 12 and 56. So they held that it's procedural. So it makes a big difference to know whether it's procedural. So this screen gets us started with, when am I going to import my state rules that you've learned to my federal practice? Does the state rule, is it intended to achieve a substantive objective? And I think that's why the Ninth Circuit has held that the anti-SLAPP statute is designed to achieve a substantive objective, right? Whereas a motion to bifurcate punitive damages is really a procedure. So we don't bring that with us, right? So I have an easy answer. And if your civil procedure teacher didn't use this, I understand. If, when they passed the law in the state legislature, there were lobbyists hanging around, it's probably substantive. If there were procedure nerds like me, who met their wives or their husbands or their significant others while they were reading Penoyer versus Neff, it's probably procedural. That's kind of a nice rule of thumb. Let's get started. Here's the cartoon. The Snow Man is on the psychiatrist's desk couch and says, when did you first realize you weren't like other precipitation? You know what? Federal court is not like other precipitation. That's the starting point. Federal court is not like other precipitation. Now, this is not a photograph of any of your judges, for sure. San Diego is a kinder, gentler district. I've just come back from D.C. and Florida and Texas. And they're not nearly as kind and gentle, of course, there. Since I'm here, I'm going to say this. There, I said they were the kindest and gentlest. But are there anxieties for practicing in federal court? You're sitting here and you say, God, I'm at federal court, there's all these rules, or you love federal court. Let's figure out why we need to do what we're doing right now and why federal bar associations and things are so helpful. You don't want to sound stupid. You don't want to say, Your Honor, I'm going to be filing a demur, and you're in federal court. And the judge is going to look at you and say, 12b-6 calls it a motion to dismiss. The home run motions in federal court, because we have judges who are, of course, self-assigned to the case throughout the beginning, are very important in federal court. Of course, that's going to include jurisdiction. Federal courts are courts of limited jurisdiction. I'm going to say that again. It's the most important statement of the day. Federal courts are courts of limited jurisdiction. They find ways to not have the case be there because of jurisdictional limitations. You need to know the local rules, of course, and what the judges do in their own practice. And the stakes can be very high in some of these cases. So that's why we care so much about it. So let's get the lingo right. Let's not make mistakes. They're called claims for relief in federal court under Rule 8. They're called causes of action in state court. If you call one the other, no one will look at you kind of funny. In federal court, it's called a counterclaim if it's the plaintiff back against the defendant back against the plaintiff. And if it's between defendants or a new defendant, they're called cross claims or third-party claims. In state court, they're all called cross complaints. So you're not going to file a counterclaim in state court. You don't file a counterclaim. If the defendants bring a claim back against the plaintiff, it's called a cross complaint. There are no DOE defendants in federal court as a general rule. You're not going to plead those. You're going to use Rule 15C for relation back for statute of limitations. State court, if you don't plead DOE defendants, you might be committing malpractice by not preserving the statute as it relates back. As I just said, in state court, we're going to call it a demur, in federal court, we're going to call it motion to dismiss. We're going to get the lingo right. We're going to get the lingo right. That's this screen just is so you don't sound stupid. If you use the word cross complaint in federal court, they'll know what you're talking about. But they'll look at you. They'll look at you as if you don't really know what you're talking about. That's the great challenge. You don't want to make errors if you can avoid them. We make enough as it is. Let me just make a confession. Because if you're getting nervous, you're going to make error in your federal court, they're going to sanction you under Rule 11. I have filed a couple briefs with typographical errors. I filed a brief once which asked the court to award treasonable attorney's fees. Treasonable attorney's fees, they're quite good. I love the one that said, it was somewhat Freudian, it said the purpose of litigation is to revolve the dispute. Yeah, that's probably too honest. And then my favorite, I represent the State Bar of California, we do their constitutional work. It had to be a brief in front of the California Supreme Court. It had to be on page 1. And it said, this case raises a matter of great pubic interest. Yeah, you bet it did. Oh, so you don't want to do that. Here we go. Let's get started. We're always going to start every federal case analyzing, is there subject matter jurisdiction? Is there subject matter jurisdiction? Because if there's no subject matter jurisdiction, the case can't go forward. And by the way, that can be raised at any time. It's never waived. You can litigate a case for years. The Court of Appeal, they can raise by an order show cause, sua sponte, no jurisdiction, and you've just wasted the entire case. So you always start with subject matter jurisdiction. You then go to, is there personal jurisdiction over the defendant? Then you go to, is there proper venue? And that's the order you do it. Some cases allow you to switch the order a little bit, but that's their general order. And then, and only then, do you start thinking about the merits. Only if subject matter jurisdiction is proper, and there's no venue or personal jurisdiction attacked, you deal with the merits. This is absolutely necessary in federal court, particularly the base, because you always start with subject matter jurisdiction. That's how you do it. All right, with that in mind, let's do it. Let's start with where we started. I want you to imagine that this room is the federal courthouse, jurisdictionally speaking, for civil cases. Got it? See the door right there? That's the front door. Case can come in here if there's a claim that is arising under federal law, front door of federal question jurisdiction. How about that one there? You kind of sneak in that door. That's the visitor's door of diversity jurisdiction. That is, we allow a federal court system, our national court system, if we have a case between citizens of different states. Hey, see the door there? There's a ticket to get in. It's got to be over $75,000 in controversy. Don't turn back. Look behind you is the removal door. It's the back door of removal jurisdiction. Case originates in state court, and amazingly, the defendant unilaterally, simply by filing a notice of removal, can remove it to federal court if it looking at the complaint, which could have been brought in federal court to begin with. And lastly, there's a side door of supplemental jurisdiction, pendant ancillary jurisdiction, supplemental jurisdiction, 1367 of Title 28. That's where that's a little side door over there. We've got a federal claim already here, and we've got a transactionally related state law claim. The key to the door, the claims are transactionally related to the federal claim. I shouldn't call it a side door. Let's call it a pet door. You ever have a pet door, you know, where that little pet goes in and out of the doorway, door within a door? Supplemental jurisdiction is discretionary. It swings freely back to state court. So let's say started with those 4 doorways. Ready? Let's start with the front door. A case can be in federal court if the claim for relief arises under federal law. The fact that the case is a federal issue is not enough. The claim has to arise under federal law, and 99% of the time that means federal law expressly or impliedly creates the right to sue. The mere fact there's a federal issue in the case, generally speaking, will not make it a federal question claim. So, I get to ask questions because I'm a teacher, right? I like to ask people for directions in my own neighborhood, Stephen Wright said, and then I grade them. All right, let's try it together. Ready? Let's try one out. Minton loses his federal patent suit in federal court. Exclusive federal jurisdiction, for goodness sake. Minton then sues his attorney for malpractice and says, hey, you messed up my federal patent case. The question is there a motion to dismiss for lack of subject matter jurisdiction? Now, if I could play the music from Jeopardy, I would do so, and I'd be the jurisdictional Alex Trebek. We're going to grant that motion. That is a state law claim for malpractice. That it has a big federal issue in it does not make it a federal question claim. Very important, therefore, as a general rule, we're going to ask ourselves, does federal law create the right to sue? If it does not, the mere fact that say is in Palco, the case cited here, that state law allowed you to bring a perjury civil claim. The perjury is in federal court. The person who was the defendant was victimized by the alleged perjury, then, after proving their innocence, brought a lawsuit under state Michigan law. That's a state law claim, even though it arose in federal court. All right. So now we've had a few PowerPoint slides so far, and we're going to have some more. So I thought, what if they had PowerPoint in 1863? One of the great euphonic speeches of all time, 272 words. I wrote a book called Romancing the Room about public speaking, published by Random House, and man, it doesn't get any better than Gettysburg Address. But if you had PowerPoint, I bet you would have done bullet points, because they can't stop themselves, can they? That's the death by PowerPoint. And then since he couldn't just say 7 years ago, he'd have to have a graph, so he'd have a graph like 7 years ago in nations. So let's just bear with us as we do PowerPoint slides together. Let's talk about the visitor's door. Hey, the visitor's door. Is there complete diversity? We're going to give, it was a hot summer in the late 18th century when they got together and said, let's have a constitution. Let's get around the Articles of Confederation. And let's create a national court system. We're going to make it a court system of limited jurisdiction, but we're going to give our national court system accessibility to those from different states to avoid the supposed biases of local states. So if you're across the street at state court here, you come over here. One of the ways to get into federal court, of course, is to file a case under diversity jurisdiction. So therefore, we need to know what are the complete diversity rules and what is the $75,000 amount coverage. So here it is. See the screen right here? If you've been to kindergarten, you can do this. Every time there's a case by getting into federal court by way of diversity, you ask yourself, what is the states or the states of citizenship of each plaintiff and the states of citizenship of each defendant? Got it? Here's the easy one. If the same state is on both sides of the line, we don't have complete diversity. Got it? Got the rule? Let's do some learning. So, how do we figure out what states there are? Well, we're going to have to look at the rules for where is an individual a citizen of, where are corporations citizens of, and where are other entities that are not corporations, like LLCs, LLPs, partnerships. Got it? Okay, let's start. Individuals. If you just took the bar exam, I apologize for this bad memory. Individuals are going to be where they intend to remain permanently, and I've already gotten there. I've got to move there. Got it? So that's individuals. So we have some issues with students and military, etc. That's individuals. Individual will be domiciled, hence a citizen of the state in which they are intending to remain permanent. So this screen you don't need to know, but it's just, how do you figure that out? Like a lot of things in law, it's factual. Where do they have their residences? I put it in plural. People have more than one residence these days. Where do they own property? Where do they register to vote? Where are their tax returns? These are all facts, and if we're going to be fact analysis of where you are. We're going to drill down to figure out what kind of facts support what citizenship they are. So we'll write that down in our little kindergarten sheet. Corporations. As you know, corporations take on the citizenship of all states in which they're incorporated. Everyone, Delaware, California, wherever they are, incorporated. And the state, also, of where they have their principal place of business, which will be where they have their nerve center. What we mean by that is basically where their headquarters are and they make the high-level decisions. And we'll write all those states down. Got it? Oh, here's a big one. If it's an entity, party, plaintiff or defendant, and they're not a corporation, they're like LLC, an LLP, a partnership, an unincorporated association, they will take on the citizenship of each of their members. So when we write down and down, it won't be where the LLP is from, it'll be where all the members of the partnership or LLC are from. Got it? And that's the case that holds that. So let's try one out. All right, now you've been in kindergarten, so do it with me. We're going to get rid of judicial immunity for this hypothetical. So we're going to have Judge Huff be the plaintiff, California, and she's suing an LLC. So do we have, let's do this by Greek chorus. Do we have complete diversity here, everybody? Everybody, I say yes or no. That's not very loud. I'm just like a morning of amens, but it's not amen. Do we have complete diversity here, everybody? Yes, very good. Because we don't have California on both sides of the line, do we? So, if the LLC were from California, it doesn't matter. They take on the citizenship of their members, not of themselves. Let me say it again. If it was an LLC that was created in California, but the members were only Floridians, we have complete diversity. The citizenship of the LLC is not like a corporation. All right, let's try it. Ready? Here we go. We're now about to do a Sarah Palin. We're going to drill down, baby. Ready? Here we go. We don't have complete diversity here because one of the members of the artificial entity is itself an artificial entity. So we have to drill down further. And we see that although we've got two Floridians at the first tier, we've got a second tier in which one of the members of the LLP, which is a member of the LLC, shin bone and knee bone, is from California. We have California both sides of the line. Therefore, when you're analyzing or challenging jurisdiction, you're going to always do the drill down and ask your client on both and or the opponent, where are their members from? And the court, I just this morning at 11 o'clock gave a speech to the law clerks and the judges on how to get 3 cases off their docket. And one of the ways was drill. And the lawyers, therefore, have to know the drilling. And if you don't know the drilling, you don't have jurisdiction. Back door, behind you. Removal jurisdiction. We ask ourselves, can the case come to federal court? And it's kind of weird. We take it for granted, we're lawyers. But the average person says, someone chooses to file a lawsuit in state court, and the other side can unilaterally, simply by filing a notice, change the sovereignty before whom that case is being heard until there's a possible remand. That's our system. So if you file a case in state court and look at the 4 corners of the complaint, there would be complete diversity or a federal question. The case can be removed by the defendant. It's a squeaky door because they've got to do it right. Within 30 days, all the served defendants have to join, etc. It's got to be removable. All right. So let's figure it out. Since it's removal, we've got to have complete diversity. It's diversity. And there's got to be over $75,000 of controversy. The party who invokes federal jurisdiction has the burden of pleading and proving it. So in an original case, the plaintiff has the burden of pleading and proving it. On removal, the removing defendant or defendants have the burden of pleading and proving removal. Therefore, they've got to plead the facts supporting amount of controversy and plead complete diversity. There may be a situation where we can press the delete key. We'll see in a moment where a party is joined who's a sham party. We don't count them. That's very rare. And lastly, as we'll see, if I have an out-of-state plaintiff suing an in-state defendant, there's complete diversity. But if that in-state defendant's been served, that case can't be removed in federal court. That's called a local defendant bar. Let me say it again. Got an out-of-state. Remember, if you have an in-state plaintiff, you won't have complete diversity. You have an out-of-state plaintiff suing an in-state defendant. The statute says that in-state defendant cannot remove the case to federal court. All right, let's try it out. Here we go. Let's play kindergarten. Do we have, if this case was filed in state court, can we remove this case to federal court? Everyone?
Yes.
Yes, very good answer, because we have no 2 states in the same line. How about this one? Can we remove this case to federal court? Seems like, do we have complete diversity, everybody? But wait a minute. If this is filed across the street, D2 is from California. The local defendant, if they're served, can't remove. The local defendant can't remove. Therefore, this is barred by the statute. Because, let's be honest about it, if the reason for that visitors coming to federal court is to avoid bias, now my mama didn't raise a fool. Why does a Californian need to avoid bias of their local court? So therefore, the statute says the local defendant who's been served cannot remove. Hey, want to get really nifty and complicated? Like you met your spouse while they're reading Panera Bread now? If D1 removes the case before D2 is served, that removal is proper. It's only if D2 has been served. You're a plaintiff, you want to stay out of federal court, serve D2 first. Absolutely, serve D2 first. And we want to talk about what happens if D2 removes before they're served. Split of authority between the districts in the United States. Can you remove that? All right, here we go. How about this? So we don't have complete diversity, but the removing defendant says, hey, the non-diverse defendant is sham. And the Ninth Circuit just ruled, in a case, it's a good read, the Grand Care case, just ruled that that's not even the same as 12b-6. You're not sham unless there's no possibility of recovery, even if it might eventually go away by summary judgment or motion. You can press the delete key in order to get complete diversity and removal, if and only if the non-diverse defendant is sham. That's a very high standard. And you've got a case from this district that says so. I misspelled the name, sorry. Here we go. So let's try this one out together. Ready? We got our thinking caps on. We're doing a little thinking. We are going to do our best to drill and figure things out. J. Paul Getty was famously asked the question, what are the 3 secrets to success in life? He said, 1, wake up early. 2, work very hard. 3, find oil. That's what you do. Let's find it. LLC from Rhode Island removes to federal court with a jurisdictional allegation that P's a Delaware LLC with its principal place of business in New York. Let's stop. Right now we know it's a bad allegation. What does that mean? It's irrelevant to jurisdiction for removal purposes. It also states that P has no members from Rhode Island. So we've got some problems here. I think we're going to grant that motion to remand. They have not met their allegation to show we've got complete diversity. The notice of removal appears to be inadequate because your job is to tell the court who are all the people in the lawsuit for jurisdictional purposes. That's the short answer, for jurisdictional purposes, right? So you got to get it right. You don't want to make mistakes in the way you describe things. My brother Steve is a district attorney. He's the district attorney in San Mateo County. Just got reelected 2 weeks ago for his, I don't know, 3rd or 4th time, some awful thing. Unopposed as always. I sent him a note that he got 100% of the votes, so what, so did Fidel Castro. And when I was 8 years old and Steve was 12, Steve says, Mom and Dad are having dinner guests tonight, Mr. and Mrs. White, and I was the 8-year-old, so I would greet them at the door, and I'd go up, you know, with the pajamas with the shoes built in, you know what I mean? And I would greet them, and then I would go upstairs. Steve says, when Mrs. White comes to the door tonight, say the following. And I did. The doorbell rings at 7 o'clock, door opens, I'm standing there with my little pajamas on. I put out my hand, I say, my Mrs. White, how promiscuous you look tonight. Steve didn't tell me the meaning of the word promiscuous. All right, and she gave me that little pat on the head of, nice boy, go to bed. The idea is you gotta know it. So let's assume that the state court complaint doesn't say a word about the amount of controversy. And you remove the case saying generally it's over $75,000. Until a couple of years ago, I would say that's an inadequate fact pleading because you didn't set forth the facts as to why it's over $75,000. However, the United States Supreme Court said for the notice of removal, you simply have to have a short and plain statement. You've alleged jurisdiction, and we'll figure it out now once we drill down and find the facts. If it's not over $75,000, then we'll have a motion to remand. But it is proper for removal. But you've got a case from your district right here that says, but you got to allege it. You got to tell us what the facts are. All right? So here we go. So let's suppose that it's in state court and they want to remove on federal question grounds. They can do so if it arises under federal law. Let's forget Grable for a minute. And if it's simply federal preemption as a defense, like the Medical Devices Act, that's not enough. But sometimes federal law not only displaces state law claims, like the Cigarette Labeling Act, which says you can't bring a suit against tobacco manufacturers for failure to warn, because it's preempted by federal law, displaced. But it doesn't replace it with a federal claim. There's a small number of areas, ERISA, labor law, copyright infringement, in which federal law not only displaces and preempts state law, it replaces it with a federal claim. So you replete it and remove it. But generally speaking, our rules we learned on original jurisdiction apply and removal. So let's try it out. This one, I know you can get because we've now learned it. Even though we're only halfway through, we've learned it. Ready? We've got a state court complaint for Little RICO, which is not complete preemption. You can bring a federal RICO or you can bring it under a state law cause of action. It's like any trust. You can bring a Cartwright Act antitrust claim or you can bring a Sherman Act federal claim. Got it? But the predicate act for the state Little RICO is alleged to be the federal mail and wire fraud statute. Got it? Okay. Can this case be removed to federal court? Yes or no? Who says yes? Okay, good. Wrong. Who says no? I got 7 votes out of this entire room. Let's try it again. Who says no? Raise your hand, please, if you don't mind joining me. Thank you. You say, no, you're absolutely right. There's a state law claim with a federal issue element. This is not a federal claim. This is not a federal claim. What's going on in your district? As I read the cases last night, you've got a lot of cases where people are removing cases at federal court that are unlawful detainer actions by saying there's some federal law that protects the tenant. It's all very interesting. But the courts are routinely remanding those back to state court because it's a state law claim that might have some federal defense to it. Not a federal cause of action. You'll be happy to know there's no federal cause of action, generally speaking, for unlawful detainer. That's across the street. So, the plaintiff in state court is the Jedi master of their claims. Right. You're here, but you may be here because you don't want to be in federal court. You just want to learn what to do if you get there. Right? You may be here because you love federal court. But the plaintiff in state court is free to plead their claim as they choose, and if they want to do it under state law grounds, assuming there's no diversity, it stays in state court. I sue my colleague for sex discrimination, let's make it that, right? Perverse discrimination. And I allege that it violates California's laws, DFEH laws, right? FEHA. I do not allege Title VII, but I could have. I'm the Jedi master. She can't remove it to federal court and say, he could have sued me for Title VII. That is a reconstruction. So the plaintiff is that you want to stay out of federal court, you don't like being on this side of the street, then plead state law claims. All right. So let's do a remand. Now look at this. I call it Remand Fridays. I'll tell you why. I've been teaching federal judges now for 30 years. I promised 3 cases off the docket at the end of my presentation. And one of the things some of the judges tell me they're now doing is they have Remand Fridays, where they look at all the removal notices and see which ones shouldn't be in federal court, and then remand them, either by an order to show cause or some other process. So let's look. Test the diversity allocations. See if it really is diversity when they've alleged it. Make sure the shams are shams. If they're not, there's no diversity. Make sure if they say substantial federal question, it's actually a federal claim. Procedurally, did all defendants join in notice of removal? Because every served is a join, other than CAFA. Was it untimely removal? They removed more than 30 days after they're served, and they have no explanation for that. Local served defendant, we've seen that. And waiver. Waiver. Meaning maybe they litigated a case in state court so long they waived it. Or better yet, maybe they signed a forum selection clause that says state court only. Let me say that again. You will always, did I know the word always? You'll always read the contract at issue in the case. Go home. You've just been hired. You're looking at the complaint someone's brought against your client, or you're drafting one. Go home, pour yourself a glass of Chianti, and read the contract. It's really fun to read contracts. You'll read the contract in that particular regard, right? And when you read that contract, you'll notice that it has some things. I love a quote from the great writer E.B. White, who said, "Be obscure clearly." That's what I think a lot of contracts are. They're clear obscurity. But one of the clauses you might not have noticed would be the forum selection clause, which now, as a result of some case law we're going to look at, tells us it's really important. And they might say state court only. That is a bar on removal. All right, side door. Same transaction occurrence, and that will involve, if I have a claim under a federal claim, if I have a transaction-related claim that adds a new party, they're a supplemental party. We're okay. So let's figure it out. It's not always. In this case, we have a deliberate indifference claim because the prisoner was killed in jail, so it's a federal civil rights claim for wrongful death, right? And they join with it, the family joins with a claim against the coroner, who then disposed of the remains improperly according to state law. Got it? Are these claims, now we have a federal claim, that could come in the front door or the back door. But do we have a transaction-related state law claim? No. The court held these, while they sound alike, are not transactionally related. One is a civil rights claim for what happened in jail, and another is for what happened with the body after the fact. The court held this was not the same transaction or occurrence. If it's not the same transaction or occurrence, it cannot come through the side door. All right. Can the court say no to supplemental jurisdiction? Yes. They can say the state claim is novel or complex, the state law claim is too big a claim, we don't want to waste our time on it, there's some other reason why I don't want it, like there's a jury trial with state law claim, not mine, or the federal claim is dismissed. This is simply a visual embodiment of 1367 of Title 28, Subdivision C. 1367C. All right? You write real fast, not to worry. One of my students said my name is Jim for the acronym JAWS in motion. All right, here we go. Ready? Here we go. I love this guy. Not only because I met Karen while she was reading Pennoyer vs. Neff, but because Pennoyer vs. Neff reminds us of that first week of law school, and we learned the subject of personal jurisdiction. So we're talking about federal court and personal jurisdiction, how does it work? Let's make it much simpler than it was in law school, I hope. This is my favorite one. Look at this one carefully, everyone. This is good. Flash. Oop, there it goes. Okay. Here's how you do a personal jurisdiction motion. In federal court, it's Rule 12b2, motion to dismiss for lack of personal jurisdiction. Or if it's service of process, it would be a B4, B5 motion. Got it? You start with the long arm statute. California's long arm statute extends to the full extent of the Constitution, so you always round first base. In other states, they have limiting long arm statutes. Traditional basis. Is there a traditional basis? In the language of Justice Scalia, is its pedigree such that we are going to follow it? Well, consent is a traditional basis. If you sign a contract, say I'm willing to consent to personal jurisdiction, you can do it. Consent domicile. The defendant lives in the forum state. Don't complain about due process and fairness when you live in the state they're suing you in. Consent, domicile, or presence. You're served while physically present in the forum state. That's power. Got it? All right. General jurisdiction. General jurisdiction is completely different than it was 3 years ago. The cause of action arose elsewhere, but are you at home in the forum state as an entity, your principal place of business or incorporated, that you're subject to jurisdiction there even though the case arose elsewhere? That doesn't happen very often, but you can sue the defendant where they are. Lastly, minimum context. You know minimum context. This is great. I'm now putting in front of you on the screen one of the great euphonic paragraphs of all of law. It's that good. Euphonic means good to sound. I mean, there's a lot of things that sound good, right? I grow old. I grow old. Shall I wear the bottoms of my trousers rolled? I shall part my hair behind. Do I dare to eat a peach? I shall wear white flannel trousers and walk along the beach. I hear the mermaids. They're singing each to each. I do not think that they will sing to me. Oh, how good is that? It has nothing to do with law. But of course it's J. Alfred Prufrock and it's T.S. Eliot, which is not nearly as good as this. Due process requires defendant have certain minimum contact with the forum state, such that the maintenance of suit does not offend our traditional notions of fair play and substantial justice. Due process. The court cannot exercise power in federal court or state court over a defendant unless they have such minimum contact with this forum state. You got that, right? So let's figure out how it works. One of the biggest areas, in particularly our federal cases, is someone says the reason you're subject to jurisdiction is you committed an intentional act that you expressly aimed at the forum state, here in California, and that you knew was going to cause harm here. That sounds like if you injure someone from California, you're subject to jurisdiction. Wrong. Let's figure out why. Because Walden versus Fiore, Supreme Court, says DEA agent in Georgia rather, the plaintiffs go through the state with 30 grand, they come back after going to Puerto Rico with 90 grand. That raises the hackles of the DEA agent, says, I think it's drug money. They say we want him gambling. It's seized, allegedly illegally. They go home to Nevada. Their lawyer sends a letter and says, this is ridiculous. The DEA agent allegedly lies about it in his affidavit. And he gets sued, you bet, in Nevada. Is there jurisdiction in Nevada over the DEA agent in Georgia? Because he injured people he knew were going home to Nevada where they're going to suffer their financial injury. Supreme Court holds no. This guy did not target the state of Nevada. So we have Walden world. When you're looking at jurisdiction, you look at the relation between the defendant, the cause of action, the forum, not the plaintiff. Where the plaintiff is an accident. It may tell us the defendant has done something in connection with them, but here, the fact they're from Nevada was entirely fortuitous. All right, so it gets worse. The California Supreme Court ruled 4-3 there was jurisdiction over Bristol-Myers in this case. The U.S. Supreme Court last year reversed. It was a consolidated case in California arising from the drug Plavix. It cleans out the insides for heart stuff, right? Hundreds of millions of pills are sold across the country, particularly in California. Bristol-Myers is an East Coast company that developed and R&D'd it out there, but sold it to a lot of Californians. This is a consolidated case, single case. 86 of the plaintiffs from California, no problem. There's jurisdiction over them. They deliberately sold the drug, they marketed it, they bought it, they were injured, no problem. It's the 592 co-plaintiffs who are from other states, joined together for the power of a state court case. And the issue was, is there personal jurisdiction over them? The Supreme Court held no. First of all, Bristol-Myers is not subject to general jurisdiction, right? Because they're from New Jersey. They R&D'd this drug in New Jersey. While they sold to a lot of Californians, these particular plaintiffs were not Californians. They're not subject to general jurisdiction because they're not at home in California. Although they do billions of dollars of business in California, that's not where they're at home. Got it? But in addition, there's no specific jurisdiction because the case has nothing to do with those plaintiffs. Okay. Now, I realize that I'm Erwin Chemerinsky light when it comes to these things. But Irwin told me that for him, minimum contacts basically described his high school dating life. I said, Irwin, me too. It must be true for law nerds that might be true of some of our high school dating lives, minimum contacts. The fact is that here, you say, does this case mean anything? Seems so obvious, even though the Supreme Court was 4-3 in California. You know what? How does it affect class actions? We have an interstate class action with plaintiffs from all over the United States. Why is there personal jurisdiction as the cases involving them? And 5 district court cases around the country have said Bristol-Myers may affect interstate class actions. They didn't target California for these plaintiffs. All right, let's go. This is a big one. Remember I said read the contract? Read the contract. That's one of the things I said. Read the contract. And you want to read the contract. So, I was reading this the other day, and I thought, what a great thing to illustrate how sometimes the government and contract are weird. This is a notice from the Department of Social Services in South Carolina. Ready? I'll read it to you. It was sent to somebody. Your food stamps will be stopped effective March 2016 because we received notice that you passed away. You may reapply if there's a change in your circumstances. I love the government. All right, here we go. Let's read. Consent. You've got to read the contract. Consent can change, particularly venue and jurisdiction, personal jurisdiction. What clauses are you going to read? In every case, but particularly important in federal, you're going to read, is there a choice of law clause that tells you what law governs this contract? And you're going to draft those, you're drafting contracts to capture the law if you can, that's favorable to your client. Is there a consent to personal jurisdiction clause? That will be enforceable, remember, second base, consent. Is there a forum selection clause, which is a venue clause, telling us where this case can probably be venued? And lastly, is there an arbitration clause? And we don't need to wait for Justice Kennedy's replacement to be brought in. We know the Supreme Court is basically enforcing those in federal court. All right, so let's try it out. Atlantic Marine, United States Supreme Court case a few years ago. They're a big construction company in Virginia. They entered a contract to build a big daycare center with the Army Corps of Engineers in Fort Hood, Texas. They also entered a contract with a subcontractor, the local Texas subcontractor, who's going to build the daycare center. Got it? And the dispute arises between the Texas daycare center subcontractor and the Virginia company for payment. Let's be clear, the entire gravamen of the case is Fort Hood, Texas. All the witnesses, the services, the issues. Virginia has nothing to do with it other than it happened to be the place where one of the parties is located. Oops. They had a contract clause, a forum selection clause that said a mandatory forum selection will be in either Norfolk, Virginia State Court or federal court in the Eastern District of Virginia. The United States Supreme Court upholds the clause. Justice Alito tells us in words to this effect, a contract's a contract, absent being unenforceable. And therefore, it doesn't matter that it's 1,523 miles away and that witnesses are going to travel. It doesn't matter. It doesn't matter that the plaintiff chose appropriately to get paid where they were doing the work. It doesn't matter all the witnesses and the private interest will be from Texas. It doesn't even really matter much there's some public interest on the rarest of cases. And we're going to give no deference to the plaintiff's choice of forum, and we're going to not even take Texas law with us when we get to Virginia. Got it? It's enforceable. And it's a proper grounds for a motion to dismiss for lack of proper venue or to transfer venue in appropriate states. That means the clause is enforceable. So in California in particular, state court, much more amenable to knocking those clauses out. Just read the case law. But in theory, you can do it in federal court too. It was procured by fraud, or you had no notice of it. It can contravene a federal policy. We have a lot of state statutes, for example, that say you can't have forum selection clauses in, say, a franchise agreement. Doesn't seem fair to let Burger King take you all the way to Florida anymore. So you got to do it where they're located, or if it's fundamentally unfair. So you can fight those to wipe out the clause, but otherwise that clause is going to be enforceable. So let's try one out. So we entered into, can we do it again? We entered into a mutual confidentiality agreement, a non-disclosure agreement, NDA. And in the agreement, we consent to the sole and exclusive jurisdiction of the courts of Harris County, Texas. Right? And I sue you, because of course it's my hypothetical and you're breaching the duty. And I sue you in California. Right? And you removed to federal court. That is a bar on removal. It's a bar on removal in Texas too. If the contract says it's going to be in state court, it's going to be in state court. That is a bar on removal. Let's be clear. That is removal that must take place within 30 days. A notice of remand. The notice of remand must take place within 30 days because it's a non-jurisdictional defect. Got it? So if you're challenging subject matter jurisdiction on motion to remand, you can bring the motion anytime. But as soon as that notice of removal lands on your desk and now you're dragged to this courthouse, you're going to calendar 30 days, as your time to make the motion to remand. Because for any defect that's non-jurisdictional, you have to make the motion within 30 days of removal. Otherwise, you've lost the remand, except for jurisdiction, of course. So this would be a non-jurisdictional attack saying that they waived the right to remove a contract. You'd make a motion to remand within 30 days and it'll be granted. It'll be granted because the case law tells it to be granted. Lots of good case law in the last year on this issue, the issue of forum selection clauses. All right, since I'm in federal court, I better tell you about Twombly-Iqbal. Twombly-Iqbal is a motion to dismiss under Rule 12b-6, as you know, challenging the validity of the sufficiency of the pleading under Rule 8. Rule 9 requires specific pleading in fraud cases. This is old notice pleading. One of my students, I think, called it Rule 8.5, because it sounds like it's a little more. Twombly-Iqbal says, by the way, Twombly-Iqbal does not apply in state court. State courts do not apply the Twombly-Iqbal pleading rules. It's clearly procedural, because Rule 8 covers it specifically. You ignore the conclusory allegations, and you only count the allegations that show a plausible entitlement to relief. Ugh. What does that mean? Well, it means more than we can cover right now, except let's see if we can get some hints. Every year, when I update my book, I've got to read all the cases, right? And I've just decided, since we have several chapters on motion to dismiss, that I'm going to try and figure out Twombly-Iqbal. And the way I'm going to do it is not to detail to you 10, what I call the top 10 examples, we'll call it family feud of Twombly-Iqbal. The top 10 examples of where Twombly-Iqbal actually sticks and works. Here we go. All right? First of all, I think the courts are saying, show me facts why it's not a suspicion. That's a good Ninth Circuit case, the Levin case. If you want to read, if you want to do a Twombly-Iqbal motion and get it granted, Levin at 765 F. 3rd 1123 is not so bad. Good example of where the court affirmed a Twombly-Iqbal dismissal. Here we go. Here's my top 10. And if you're the plaintiff, plead more facts. If you're the defendant, you can challenge it. Conspiracy without facts. Bad faith without facts. Color of law without telling us why. Malice without facts. Retaliation without facts. These are the top 5, in my experience, where courts affirm dismissals under Twombly-Iqbal. Why? Because maybe they don't have the facts. Don't get me wrong. The court will give leave to amend. And in that amendment, the plaintiff is going to come up with facts. But if they can't under Rule 11, then the case will go away. And oftentimes you allege conspiracy just to get everybody. I allege conspiracy because everybody in the room. Or I say bad faith without saying why. So these are 5 examples. Got them? Now let's go to 5 examples, my top examples of plausibility problems. Ready? Here we go. Here we go. Now, my mother, who raised a good boy, would be proud to have me tell you that one of the problems on this page is that sometimes plaintiffs' lawyers, when they file complaints, put manure in a shotgun. There is another way to say that that's slightly more alliterative. But manure in a shotgun means they just throw it out there and they name everybody or they don't say why. You name the 4 people in the front row here by saying you're all the alter egos of each other. But I don't say why you're the alter egos. Courts will make you drill down because otherwise you get stuck in this lawsuit for months and years before you can make a summary judgment motion when they don't have facts to show why you're even involved here. Qualified immunity. You've got a governmental defendant. There seems to be some reason why it's not a clear violation of law. The court will make you drill down and explain why it is. Manel, a civil rights claim against a municipality where you allege that they have an unconscionable policy. Why not say what the policy is? Multiple defendants. Here's my big one. This is really the manure in the shotgun. I just name all of you in the room, and you all aided and abetted in the defamation that she did of me. You say, well, Rule 12, we've got to accept the allegation. Yes, you do, but the court will grant a Twombly-Iqbal motion to say, why am I naming the rest of you, and tell me why you're responsible. That's a perfectly valid Twombly-Iqbal, and it actually might work to protect your client. And lastly, Twombly itself, which is complex claims. That was an antitrust claim. Now, remember, do not engage in Twombly-Iqbal just because you want to. So you're a defendant for Twombly-Iqbal. No knee-jerk motion just because you want to make life miserable. This is not LA Superior where motions take years to get decided. They actually decide things around here. Bring a winner. If you can get rid of the case or a claim and doing something to limit discovery, etc., bring a winner. And if it's really, really strong, then consider asking the court to stay the initial disclosure in Rule 26. Bring it. If you've got a dispositive defense, bring it. That's, clear on the face of the pleadings. That's our defendant. You're a plaintiff. You want to avoid these things, obviously. Be not afraid. Twombly-Iqbal should not scare you. If you've got the facts, you can plead them. Remember that just because they're alternative explanations does not mean you're not going to have a Twombly-Iqbal motion. And get the facts from your client. And if the other side possesses the facts, highlight on information and belief why you think they have them. Because you don't want to get Twombly-Iqbal. That's no good. So Twombly-Iqbal is a big thing in federal court. The judges know it very well. Here we go. Let's just do some quick learning. Ready? Evidence. So you need no Daubert. Daubert basically going to say that, if you're going to put on an expert, you got to make sure that they can help the jury understand it and that it's sufficiently consistent on judge sides. That's Daubert, right? That's 7-2. We don't need all the details. That's Daubert. You know the Daubert. We don't have Daubert in state court. So, reliable is a big issue. If you were going to put, the Wolfman on as evidence, you could put on evidence of the phase of the moon. You cannot put on that since the Wolfman is there, that means certain people act a certain way. What is on your right side is Daubertized. What is on the left side comes in as evidence. That's not my example. That is the example of Justice Stevens in Daubert. Okay, I'm stealing it here. Okay? But the idea is, think of Daubert as if there's an expert challenge, you're going to ask for a Daubert hearing. Okay? Summary judgment. Oh, does summary judgment matter in federal court? Oh my goodness. The judges are not only in for life, they have your case for the life of the case. And therefore they're incentivized to get rid of a bad case if it's not justified. So, this screen I'm going to call my Family Feud analysis of summary judgment. Ready? You know Family Feud, the top answer. You want to win your summary judgment motion. The number one Family Feud way to win summary judgment is to tell the court they're deciding a pure question of law. Statute of limitations, statute of frauds, res judicata, some clear-cut question of law that now the undisputed facts show they can't get to a jury. Okay, let's go on the left side. That's Celotex. You show to the court why there is insufficient evidence as to a required element of the plaintiff's claim. And I say plaintiff because almost always defense motions, right? Plaintiff's claim. And the plaintiff has to say, no, I can get to a jury, and here's why. But you focus the court on the missing element. See on the right-hand side? That is the most commonly brought summary judgment motion and the most commonly denied, or reversed. The defendant says, there's just not evidence as a whole to get here. It's a bad case. And they persuade their client to write and file this $30,000 motion because it'll, quote, educate the judge. That's nonsense. You're educating the judge to find there's a tribal issue of fact and a bench memorandum from the law clerk that's in the file on the computer that says why it can get to a jury. I'm not so sure. What's the difference between 12B and Rule 56 motion? 12B is the motion to dismiss, 56 is summary judgment. This motion to dismiss tests the legal sufficiency of the complaint. We accept the facts as true. Summary judgments test the factual sufficiency of the evidence. 12B6 presumes the well-pleaded facts. Rule 56 does not. You only look at the evidence. On 12B6, the court often, particularly 28, gives leave to amend. And on Rule 56, you don't get amendment and say, hey, I need to get out of this motion for summary judgment. You've had time, unless it's really early in the case. So this screen just reminds us of the difference between 12B6 and Rule 56. 12B6 motion to dismiss, 56 motion for summary judgment. We're almost getting law school down in an hour. How good is that? We're doing our best, I promise. All right? Now, discovery. What do you need to know? You need to know Rule 26 when you disclose. Witnesses, documents, damage, calculations, and insurance. That's Rule 26. You know that? You know that. Rule 26. Witnesses, documents, damage, computation, insurance get exchanged at the outset of the case. Got it? How are you going to save money with all this ESI? You're going to meet and confer with the other side. What are you going to meet and confer with? I'll give you these slides and take your pens down and let the smoke pass. I tried a case last year in which in the middle of trial, the local paper reported that every time Wagstaffe spoke, the court reporter closed her eyes, tilted her head back, and looked like a blind jazz pianist. I was going so fast. I get it. Let's meet and confer and talk about protocols of production. Let's meet and confer and talk about privileges. Let's meet and confer and talk about maybe how you keep your documents. Let's get together, preferably with food, and let's discuss how to make this case more manageable when it comes to electronic discovery. It is a disaster in the practice of law, particularly in federal court, and the duty to preserve. So and by the way, if metadata is going to be a part of the case, then let's have metadata. Let's get that down. What are you doing in metadata? Let's get it down. Let's have this. I'll send you these slides, I promise. Here we go. You're going to manage costs and notice the top of my managing costs, food. Why do I want you to meet with the other side with food around? Because people are more reasonable when they're eating. And therefore, you're going to introduce yourself to the opposing side. You're going to say, why don't we get together and let's talk about making this case more manageable. You know the number one speech the federal judicial center has asked me to give the last 5 years? It's called Taming the Beast of Electronic Discovery. Ugh. All right, now, at the end of every semester, I give out 10 cases. 10 cases at the end of every semester. And I say, these are my top 10 cases, right? So, Erie Rail versus Tompkins, number one civil procedure case, by a mile. Celotex, our summary judgment case, big case to know. International Shoe, the modern, that was, you saw the screen, that was something that was euphonic. Substantial justice and fair play, that's due process. Hickman versus Taylor, what a great case. What a tectonic case that the federal Supreme Court declared that we have work product. Man, the rules came after. Twombly-Iqbal, man, we got to put that up there, but it's only one case because it's the same. It's just trick ball. Hansberry versus Lee, what a great case, everybody. Hansberry versus Lee, the precursor to Rule 23 in class actions. Lorraine Hansberry's parents who had the courage in Chicago to challenge that racially restrictive covenant, and how it didn't matter that someone had had a sweetheart, quote, class action to have it declared legal. They didn't get their due process rights. Penoyer versus Neff. That should not be there, but I met Karen while she was reading Penoyer versus Neff. I'm keeping it there because last time I said that in the crowd, Karen stood up and said, I wish I'd been reading something other than Penoyer versus Neff. Motley, which says federal defenses don't get you to federal court. Gibbs, which says we have supplemental jurisdiction. Gibbs is supplemental jurisdiction. That's what precursor to 1367. Atlantic Marine, our venue case. Oh, look at that. Erie Rail versus Tompkins, an amazing case. Celotex summary judgment. International Shoe personal jurisdiction. Hickman is our word product. Twombly-Iqbal, Rule 8.5. Hansberry is an amazing case. Read all about it. It led to, I think it gave the courage to Lorraine that her parent did this, so she wrote Raising the Sun and won the Pulitzer Prize. Motley, Gibbs. How fun is this? It's really that good. Now, you're in federal court. We've gone almost an hour. All these things going so fast. This federal court's hard. I said earlier, be not afraid. Be not afraid. Seamus Heaney was the poet laureate of Ireland. An amazing poet if you ever read his poetry. Just 2 years ago, he passed in his 80s. And it took a couple weeks in the hospital, like so often happens, and his wife and his son were watching on the bedside. And the doctor said one particular morning, he's going to go soon, but it won't be for a day or two. So they authorized them to go have some lunch. Like so many people, when they pass, they now realize they can pass on their own sometimes. Seamus Heaney knew he was going to die shortly. He takes out his cell phone, and he taps a little message to his wife, and it says, Noli timere. Noli timere. And then he passes away, and his wife and his son come back. Noli timere. He knew his wife would understand, because it's Latin for be not afraid. And he knew his wife would know without him having to type any further words, that the rest of the Latin phrase would be, for I will be with you always. We don't need to be religious about this. We just say that federal court has a little bit of that religion to it. Be not afraid, for I will be with you always. Unlike you know what Churchill said? He said the most exhilarating thing in life is to be shot at without effect. Go to federal court, know that you need not be afraid because you got the basic rules down, know the local rules, and shot. So you made it. You made it to the end of the race. We got an hour of subject matter and personal jurisdiction and venue, all in 1 hour, all of law school, all in one particular place. You made it. You made it in that particular regard. Now, Stephen Wright, my favorite comedian, as you saw quoted earlier, said, I booked a flight the other day, and the clerk asked, how many people will be traveling with you? And I said, I don't know, it's your plane. I'm so into that. There's plenty of resources available to you. You've got a program coming up with judges who are going to tell you how it's actually run and doing it so very well. And you too can make it work in this particular hour. Let me end with this. Muhammad Ali was on a plane in the mid-70s. He was the champion boxer of the world. He's in first class, and the flight attendant says, Mr. Ali, we're about to take off. Could you please put on your seatbelt? Ali looks at her and he says, Superman don't need no seatbelt. She looks at Ali and she says, Superman don't need no airplane. Please put on your seatbelt. I'm just a seatbelt. Thanks for spending some time.
hour break?
After this panel will be a break outside with coffee and cookies, so just one more hour. It is my pleasure to introduce all of you to Judge Gallo and Judge Burkhardt. Judge Gallo was appointed as a magistrate judge in 2009, and in 2017 he was reappointed for another 8-year term. And Judge Burkhardt was appointed as a magistrate judge in 2014. During their presentation, Judge Gallo will address discovery disputes, how to avoid them, and what to do when they arise. And Judge Burkhardt will address best practices in settlement conferences, including early neutral evaluations and mandatory settlement conferences. Thank you both for being here.
Thank you. So I'm going to introduce myself. I'm going to ask Judge Gallo to introduce himself, and then we're each going to spend about 15 minutes on our respective topics. Feel free to ask questions as we're going through, and then we're going to hopefully save some time at the end for any more general questions that you might want to ask of us as magistrate judges. We're not as scary as district judges. I'm less scary than Judge Gallo because I've been on the bench for 4 years. He's been on the bench much longer than that, more than twice that. But I want to just let you know where I came from. So I've been on the bench for 4 years. When I started law school, I practiced law in this jurisdiction. Ever since I graduated, I've only practiced in San Diego. I started at the law firm of Baker & McKenzie, where I was for 6 years. And then I went over to the U.S. Attorney's Office, the criminal division, where I met Judge Gallo. I was there for 20 years doing criminal prosecution before I was appointed to the bench 4 years ago. You want to just talk a little bit about your background?
I never had to work for a living. I always worked for the government, either in the Marine Corps or with the U.S. Attorney's Office, either in Chicago or here at the U.S. Attorney's Office. And like Judge Burkhardt, I was with the U.S. Attorney's Office for 20 years before I was fortunate enough to get this job. And so here we are.
So I'm going to start by talking about settlement conferences. Federal court is very different from state court in this respect. The magistrate judges in federal court assist the parties with settlement conferences. This is a service that on the state side, folks have to pay big money for. Also, federal litigants also go to private mediation and pay big money for it. But in federal court, this is one of your options for trying to resolve a case through mediation. In most cases, there will be 2 different types of settlement conferences set as part of the schedule that's given out. The first is called an early neutral evaluation conference. And that occurs before discovery is launched. And the second occurs pretty much right about the same time that discovery closes, and it's called a mandatory settlement conference. Each of them is with the with the magistrate judge assigned to the case, and the first one, the E&E, the mandatory settlement conference is part of the federal system. You would have one of those no matter what federal jurisdiction you practiced in front of. But E&Es are unique to our district. There's a few other districts that have it. We started it, and a lot of people who practice in other jurisdictions or learned from people who practiced in other jurisdictions aren't aware of it and don't really realize what it is or how effective it can be. A lot of people, both attorneys and litigants, come into E&Es very skeptical, thinking it's too early, we haven't done any discovery, we're not ready to settle this case. We're barely equipped to do a reasonable evaluation of the case. But amazingly, I think, the magistrate judges in our district are very successful at resolving cases at the E&E. We don't keep official statistics on it. When I started, I was told that when the magistrate judges informally kept numbers, the conclusion they reached was that 25 to 40% of cases were settled either at or within 60 days following an E&E. So that's pretty cool and pretty impressive. And I say that because, unfortunately, parties don't necessarily come in prepared because they don't know what it is and they don't really believe that their case can be resolved, and so they come in underprepared. And so I hope by talking to you today, it'll give you a different perspective on these pretty unique hearings. I'll tell one more story about a case that I had a number of years ago. It was a dispute over the benefits under a life insurance policy. It was the carrier's position that the person who took out the policy had defrauded the policy and had misrepresented his health condition when he obtained the policy. This was unbeknownst to the family members. The family members were not prepared to even contemplate that this was a possibility, having known their loved one for so many years and known him to be a person of great integrity. Before the E&E, the attorney for the carrier put together a binder where the application, each question of the application that they felt was fraudulently answered was broken out and cross-referenced against the available medical records from that same date and time when the application was filled out. They were thoroughly prepared. They came in, they were willing to share that binder with the family members and the would-be beneficiaries of the policy, and we were able to resolve the case at the E&E before the parties had to expend a lot of money and resources on proceeding with litigation. And I commended the attorney on the efforts that she had put in so early in the case, and she said, well, a few weeks ago you presented at this panel, and we sent a member of our law firm to it, and then the member of the law firm came back and sort of recapped what you had covered. And he talked about what you said about E&Es and the importance of being prepared, and we put that out to the whole firm. If I had not had that added understanding what this is, I probably would not have put in that time and work. So, just a little war story. All right, so tips for E&Es and mandatory settlement conferences, and I'm going to talk about them the same, because what I'm really focused on is the similarities between the two, the part where you're actually dealing with trying to get a case resolved. And the first thing you can do to prepare well for a settlement conference comes before you take the case. So as young, new lawyers, and even as experienced lawyers, there's a lot of pressure to bring in work in the door. Bring work in the door. I don't care if you're doing plaintiff's work or defense work. Bring that work in the door. And so you are going to be pursuing would-be clients who are considering your services and the services of other lawyers. And so the first temptation is to do what you need to do to get that case in the door, and that can lead to two potential downfalls. One is overpromising what you can do for a client and setting unrealistic expectations. And the other is accepting at face value the representations of your would-be client about what the evidence is going to show. They're not trying to deceive you. That is their reality. Everybody lives their own reality. And that is what that client is going to present to you. If you make a decision to take a case and you make representations about the strength of the case based only on what you receive from your client without doing some basic investigation, you run the risk of getting yourself committed to a case that you may not want to stay with, and certainly run the risk of overpromising and setting expectations that have to be reset. So my first piece of advice in preparing for settlement conferences is don't set unreasonable expectations in the first place. The next step, when you're actually faced with a settlement conference and you're preparing for it, and I'm talking specifically about settlement conferences with the assistance of a magistrate judge in federal court. There's a number of things that you need to do to prepare. One is basic investigation, basic preparation that you would want to do no matter what, no matter who you were going to a settlement conference with. You know, you want to make sure you are up to speed on the facts, up to speed on the law. If your settlement position hinges on ultimately persuading the district judge either at summary judgment or in terms of jury instructions that the law is on your side on a particular issue, if that's a critical piece of law, bring your best case. Bring your best case for that proposition and be prepared to talk about it with the judge the magistrate judge and with counsel for the other side if you're asked to do so. So be prepared on the facts, be prepared on the law, and then prepare your client. Make sure your client understands what this is. For one thing, make sure they understand that it's a court proceeding. Even though it's informal, even though it's gonna be in chambers and not in court, it's important that your client understand this is one of the judges on their case. This judge is going to be hearing the other matters, and they need to treat the proceedings respectfully. They need to be there early, they need to be dressed appropriately, they need to use appropriate language, and all of the things that you would do to prepare them if it were another kind of court hearing. Make sure they understand the purpose of a settlement conference, and make sure they're prepared to go in understanding the value of settlement and understanding that compromise is the cornerstone of settlement. I do a lot of hand-holding with litigants in my settlement conferences. I like to listen to them, hear them out, make sure they feel heard, and I also try to deliver messages about the value of settlement. And one of the messages that I deliver, and you can deliver to your clients going in, is we have the greatest judicial system in the world, possibly, arguably. And it's the participation in the system itself is free. You don't have to pay other than the filing fee. You get the judge's time, you get your court time for free. But that does not mean it's not extremely resource intensive. And it not only does everybody understand how expensive, discovery is, how expensive it is to motions practice, all that attorney time, but it takes a real emotional toll on litigants. And the peace of mind you can get from settling a case instead of having to try it is almost immeasurable. And if the parties can go in appreciating that there is value to settling that is separate and apart in addition to either the money they get or the money they save, depending on which side of the V they're on, that is going to set the right tone and help people be prepared. It is very frustrating. I'll share some frustrations that that magistrate judges have, and then I will wrap up because I've already used up my 15 minutes. Some of the frustrations is parties who come into a settlement conference without a starting position. You don't need to know where you're going to end up, but you need to know where you're starting. As a plaintiff, this is your case. If you do not know what you want to get out of the case, then you haven't done your homework, both in terms of the legal and factual research and that basic conversation, that processing. What are you trying to get out of this? And on the defense side, I know we haven't, if it's the E&E, I know we haven't launched into discovery, but that doesn't mean you can't come in with a settlement position, and you should do that. Another frustration is people who come in with the wrong parties present. Not an issue with plaintiffs, this is an issue with the defense. When your representative of your party is not the person that has authority to make the decisions. It's extraordinarily frustrating to the process. It's undermining of the process, and your client may well find that they are on the unhappy end of an order to show cause if the wrong person is present. Don't assume you know the end time of a settlement conference unless you have heard that from the judge or the judge's staff. Don't assume that if it starts at 9, it's going to be done by 12. Don't assume that if it starts at 1, it's going to be done by 4:30. Don't book that flight out of town or that train unless it's movable or you've cleared it with the court, because you may find yourself there till 5 or 6 or 7 or, in at least one case of mine, 9:45. So just quick tips, and then I'm going to turn it over because I don't want to use up more time.
All right, I look around here and I see some familiar faces from prior introductions to the federal court like this and other seminars, so if you hear some of the same old jokes, be polite and laugh anyway. So I'm going to discuss discovery disputes and how to avoid them. My best advice to you is to don't have them in the first place. One of the things, just piggybacking off of what Judge Burkhardt said about frustrations for judges, are parties that incessantly have discovery disputes that they can't resolve, and they're constantly calling in. Now, we all have different chambers rules on how we personally want to address a discovery dispute. Some judges say you have to call in first with that discovery dispute. Some judges say just file a motion. So you have to know what the judge's chambers rules say. And what I would tell you is, even if you've read mine or Judge Burkhardt's chambers rules the last time you had a case with us, even if it was last month, you should reread those rules again and refresh yourself, because sometimes we change. We change our way we practice because we learn things. We learn things coming to seminars like this. We learn things from a prior case that we need to tweak our method of doing business. And so we do change and we evolve. We're not stagnant or stationary beings. And so as things become known to us and we like a better practice, we're going to make that change. So my first piece of advice to you would be to read the chamber's rules of the magistrate judge you're in front of and know how that judge wants to have disputes handled specifically, or E&Es, or settlement conferences. And please, don't call in, don't look at us as your discovery dispute abuse hotline. That, we're going to talk you off the ledge just because you can't agree and you've given no effort to try to resolve your discovery dispute. So you get a response to an interrogatory or request for production of documents, and it's not what you thought it would be, or there's an objection and you have an issue with that. You don't just pick up the phone and call your worthy opponent and say, I have an issue, I don't like your response, and the other side says, well, tough, and you think that that's the end of your good faith meet and confer effort. That isn't. And then you call the judge or whatever the judge prefers under their chamber's rules. Eventually we will catch on and realize that you're not putting in the effort to try to resolve these disputes. And I start off with how you resolve the dispute before how I resolve it, because I don't know if anybody's heard, it's not big news, I've been under your radar about this zero tolerance policy that the Department of Justice has just instituted here a month or so ago, and how that's ramping up criminal prosecutions. Well, that's going to have a ripple effect on us as magistrate judges and our time that we have available to devote to civil cases. And it may drastically impact our ability to service your discovery disputes and other things that you have going in your civil cases. And so I think all of us as magistrate judges try our very best to resolve your disputes just as quickly as we learn of them, because we know that if there's a dispute hanging fire, that may impact in a domino fashion other discovery that you have forthcoming. So for example, you ask for documents, the other side says they're not going to give you the documents that you want, or they don't give you all the documents that you believe you're entitled to, and you have a deposition scheduled of a particular witness that depends on you having those documents ahead of time. But you've scheduled that deposition because you're being diligent and in anticipation that you're going to have the documents, but you don't have them. Well, getting in front of us to resolve that dispute may take more time than it would have otherwise before this policy came into effect, the zero tolerance policy I'm speaking of. And that then delays that deposition, that then has a ripple effect and the domino effect with other discovery. And discovery is held hostage because of one dispute that hasn't been resolved. So there's going to be more of an onus on you to really put in the effort, the good faith effort, to try to meet and confer, earnestly, genuinely, with the other side to resolve these disputes. And I'll go back to one of those later slides in Professor Wagstaffe's presentation a moment ago with the pyramid with the food at the top and, you know, how are you gonna manage? I think he was referring to ESI, but how are you gonna manage all of this? Well, those are the things you're gonna have to do. You really have to sit across the table with the other side. And we have a local rule that if you have a discovery dispute and the parties are from the same county or district, you have to meet personally with the other party. You can't just pick up the phone, or you can't just email or Twitter or whatever you all do. You have to actually meet and confer. Now, if you're separated by counties or states or districts, then it's permissible to pick up the phone, but you at least have to talk to them on the phone to try to resolve the case. And that's what you have to do, because your clients are depending on you to have under Rule 1, a speedy, just, and inexpensive determination of this discovery dispute. It's not just the judges who are tasked with that responsibility, but you as lawyers are tasked with that responsibility. And now, since I think December of 2015, the parties are also tasked with the responsibility of trying to resolve the case as quickly as it can be with the least amount of expense. And so because there's going to be built into the system, I think, a delay in our ability to service you, that puts more of a burden on you to really have meaningful conversations with your client. Be willing to compromise on discovery. Do you really need something? Or is it just nice to have? So I mentioned Rule 1. I also mentioned Rule 26. It talks about proportionality, which is another big catchphrase these days. And it's always been around in the rules, but it's specifically since the amendment to the rules in December of 15, it's now kind of front and center that your discovery request should be proportional to the needs of the case. And there are 6 non-exhaustive criteria that you should use when you're making your discovery request. So make your request for discovery as specific as you can. And if there's going to be objections, the objections should be particularized and specific. Oftentimes we see, and this leads to, needless disputes. I want all correspondence, since Christ was a corporal, about A, B, C, and D, and E, and F, and down to Z. And you really don't need all the correspondence. You don't need the little, note, hey, or email or text, where are we going to go for lunch? I mean, technically that would fit within that response or that request.
Especially if you use the dreaded including but not limited to.
Yes.
Which
There
is
you go.
not a narrowing clause.
No.
All correspondence, including but not limited to.
Right. So those things create unnecessary litigation and the waste of your time and the other side's time. Because the other side's simply going to say, it's too burdensome, it's vague, I really don't know what you want. So make your request specific, and make your objections, if you are going to object, make your objections specific. So both sides know what they're talking about. And then I know as a judge, or magistrate, Judge Burkhardt knows as a judge, what the dispute is all about. And perhaps if you make specific requests and there are specific objections, you might just be able to work through during that meet and confer process a compromise. Okay, I really don't need all the text messages for eternity. I can limit it to just a year. How's that? Does that help you? Yes, a year is fine. That's not too burdensome. We have the ability to bring up these documents. So make the request specific, make the objection specific. Now, all of us have chambers rules, as I have indicated, and you should be aware of those chambers rules, because in my rules, I tell people, if you're going to make these very broad-based requests, I'm more likely going to deny, or sustain the objection that might be made that is overbroad and vague. Because you're not helping. You're not helping yourself, you're not helping the court, you're certainly not helping your client, and I have no direction as to what you really need. Similarly, if you make a broad-based boilerplate objection, and each objection is just cut and paste from the one before it, you know, it's burdensome, it's vague, it's oppressive, it's irrelevant, it covers the attorney-client privilege and work product doctrine, I'm more than likely going to overrule your objection and make you answer the question, because you really haven't given me any direction as to the very substance or basis of your objection. I also—
Can I just add to
Sure.
that is also now expressly prohibited
That's
by
right.
the rules. So for all the other reasons you should not do it, don't do it, because it's expressly prohibited by the rules.
That's correct. I also abhor, I object for A, B, C, D, but notwithstanding the objection, I am providing documents 1, 2, and 3. Well, I don't know if there are more documents out there that you're withholding. And so, if you are withholding, if you have a legitimate objection, that's fine, to a part of the request. Make that objection known. But if you're also providing documents to a separate part of the request, then make that known. Be specific about what you're providing and what you're withholding. And if you're withholding anything that might be relevant or responsive based upon privilege, attorney-client or the work product doctrine, then please, 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 at the same time that you're providing a response, provide that privilege log to the other side so they know what you're withholding. Because if they don't know, that's just going to invite more and more litigation and discussion between you that's really unnecessary, could have been avoided in the first instance. So the best way to avoid discovery disputes is to have honest, and this goes back to Judge Burkhardt's point, honest discussions with your own client about what it is that you want out of this lawsuit, or how you're going to defend the lawsuit. And be realistic about those and manage those expectations and be realistic about them. Don't set these unnecessary and unrealistic expectations, because if you do, then you are going to want the sun, the moon, and the stars from the other side, because that feeds into the narrative that you've provided your client. And if you're the defense, you're going to object to everything, because that feeds into your narrative that the other side doesn't have a case, and our case is absolutely foolproof and we're going to win it. And we're going to fight like hell to show that. And when you do have a legitimate discovery dispute, after you have realistically, genuinely tried to meet the other side in a meet and confer process, and you just can't resolve it. And there are those cases where you just cannot resolve those discovery disputes. I understand that. Judge Burkhardt understands that. We all understand that there may be very legitimate reasons why you're asking for a document. There may be very legitimate reasons why the other side can't provide it. You just cannot bridge that gap after you've tried. And if after you have tried, under my rules, you jointly have to call the chambers and say, we have a discovery dispute. When you do call chambers, and I think all of us would prefer this, do not try to argue your case to our law clerks. Simply say we have a discovery dispute about a request for production of documents or interrogatories, whatever the case may be. Now, if I'm available, I'll get on the phone, because I don't want to read paper. I don't want to read motions or legal briefs about discovery disputes, because in my view, most discovery disputes can be resolved simply by getting on the phone and talking about it, because they're not all that complex. But there are some that are. And if they are, then I may ask for some briefing. Minimal briefing, a few pages. You can attach some exhibits that don't count in that pagination number, but I'm not looking to reinvent the wheel on all this. I don't want to do that. And so when you do call in, be just matter of fact, and that's why I require that both parties be on the phone together, so one doesn't try to get the jump on the other or gain some unfair advantage by slipping something into a law clerk who might take notes if I'm not available to get on the phone. And then my practice, generally, I'm before zero tolerance, is to get you back on the phone within a day or two, at a time that's convenient for all of us, and talk about it and hash it out and be done with it and you're on your way. Or issue some sort of order that gives you direction as to what needs to be done. File something, file documents, send me the interrogatories in question and the responses, and then we'll have a discussion later. The only time that I'm gonna have the parties come in, and physically come into the courthouse, because I go back to Rule 1 about the inexpensive and just and speedy determination of lawsuits, is when I think the parties are not doing their job in meeting and conferring in good faith. And now I want to see them, and I want them, and I may even require their clients to be present as well. I want to see them so I can judge for myself, face to face, whether they really and truly are attempting to resolve the discovery dispute in a meaningful way. Bottom line here is, I think it's going to be a little more difficult, more challenging to have FaceTime, telephone time with the judge because of our responsibilities on the criminal side. The criminal matters will take precedence over civil matters. We are doing our best to manage this criminal increase, caseload increase. We're constantly meeting and trying different methods and procedures to make our jobs more efficient on the criminal side and allow us the opportunity to continue to serve the civil matters that we all have. But I think in this new world that we have, at least as it now presents itself, that as far as I'm concerned, I'm going to make the burden be placed firmly on your shoulders to try to resolve these disputes and not bring them to me. And only bring them to me if you absolutely have to. That's what we're here for. All right, I think.
Why don't I just jump in?
Yep.
On my, just the ways I'm similar and a little bit different from Judge Gallo. Like Judge Gallo, I have the parties call in, both parties on the phone. My chamber's rules are specific, and I'll address at my case management conferences. I want some level of detail provided, not just we're having a dispute over an interrogatory, but really what the issue is, if the dispute is over. Again, I don't want it argued, I just want it identified. Because with that information, I will either do what Judge Gallo referred to, which is get the parties on the phone, or if I can tell from the nature of the dispute, for example, almost without exception, if the dispute is over an attorney-client privilege issue, I know the parties are gonna need to brief it, so I'll give a briefing schedule. But virtually every time, as Judge Gallo indicated, I'll get minimal information from the parties, and it might be the language of the requests that are in dispute. And then within 1 or 2 days, I try to get the parties on the phone, and I work with them and try and get them through the dispute. I will not, some judges will, but I won't. I won't give answers in that call, because the way I look at it is, I don't have a discovery motion on file. I am aiding the parties by providing insights, and then from there I send them back out to meet and confer further, and hopefully with the input that I provided, they can resolve the dispute at that point between themselves. It is, I talked about sort of frustrations of judges with respect to settlement conferences, my frustration with respect to discovery disputes, is when I get the parties together on the phone, they've left a message for me, they've represented that they've exhausted their meet and confer efforts, and then they get on the phone with me, and they don't even know what their dispute is. One party will say, you know, I'm upset because they won't give me X, and the other side is saying, oh, I'm giving you X. I intended to give you X. I'm gonna give you X by the end of the week. Or some other indication that they don't even know what's being disputed. That's very frustrating for me, and I assume it's frustrating for all my colleagues. You have not thoroughly met and conferred if you don't even know what your positions are.
I think we have a few more minutes for questions. Any kind of question?
I heard from the opposing counsel a concern that if we went into an EA that the magistrate judge would have to recuse himself because he knew too much about the case. Does that happen very often?
Okay, Okay, so the question is, if after the E&E, then does that magistrate judge have to recuse themselves from the case? So as magistrate judges assigned to a case, we have three primary areas of responsibility. We handle the scheduling issues, we handle discovery disputes, and we handle settlement conferences. That's if the parties do not consent to us. If you consent to us, then we become your judge for all purposes. If it's not a consent case, if there's a district judge who's going to be handling the dispositive issues, then it is the philosophy in this district that there is nothing about being engaged in the settlement conferences that would disqualify you from serving in the other roles that you have on the case. Now, I'm very careful, and I think all my other colleagues are, that I need to keep aligned with the party. So if I am meeting ex parte with one party because they're present for a settlement conference, and they want to launch into an issue they have about a discovery dispute, I will stop them right up front and remind them that ex parte communications are appropriate only in the context of my role as a mediator on the case, and that any discussion that affects my other roles, both parties have to be privy to. So what you may have heard and what you may be referring to is sometimes after a settlement conference, the parties will then consent to that judge. Unless there is an express waiver with respect to that judge being the judge for all purposes, in spite of having participated in a settlement conference, that creates a conflict. Or if you're set to have your first settlement conference with a certain magistrate judge and the parties consent, that magistrate judge will put the case back into the wheel to be assigned to another magistrate judge for handling settlement conferences. Did that answer your question? Do you have anything to add to that?
No, I think that's pretty cool. Any other questions?
We carved out a lot of time unless everybody's anxious to get the snacks and be done.
In terms of the objections to discovery, I've worked for a long time in state court litigation, and that's pretty much what everybody does, is the boilerplate objections. So if I'm handling a matter in federal court, can you give me an example of what you're looking for that's not boilerplate? Like, do you want the objection with then a because this is how it applies? That kind of thing?
I'll take the first stab at that. So the question is, when you're making objections to discovery, and you know it's vague or overbroad or whatever the objection might be, what do we want to see as magistrate judges that adds sort of meat to the bone of that objection? And for me, let's just say it's an objection that, or a request that's asking for documents. And your objection is that there's 1,000 documents out there that might be potentially responsive to this. And it's not just a matter of hitting a button on a computer and all these documents will just automatically be generated. That we're going to have to do perhaps a manual search for these documents because the way the business is run, they don't keep it in a certain fashion. And it's going to cost us, or my client, $10,000 to do this search. It's going to cost my client $100,000 to do the search for these documents. It will require 2 or 3 employees, 4 or 5 days working nonstop, or whatever, The only thing in controversy is a $50,000 contract, so I'm going to spend $100,000 on a $50,000 dispute, for example, and so the request is disproportional to what's at stake in the case. So that's an example of what I'd be looking for, as opposed to, it's overbroad, it's disproportional to the needs of the case, but tell me why it is. And I think in a few sentences you can do that in a way that I just described. Or if the question is so vague, why is it vague? Well, it's vague because I could answer it this way or I could answer it that way. I really don't know what they're talking about. They haven't been specific. So anything that's more than just the boilerplate, burdensome, oppressive, overbroad, vague, is what I'm looking for. A simple explanation may do it for me, along the lines of what I just described.
And similarly, for me, I think what Judge Gallo addressed initially in terms of the proportionality, for sure I need to see that by the time a dispute is before me, if that is what you're relying on. If you're saying it's disproportionate, that conclusion is always going to be insufficient. I need to know what resources are going to need to be expended and what potential value that evidence has to the case. In terms of the initial objections being filed, I feel like the impact of this rule is being very slow to roll out. I find a lot of abuse of this. My standards are pretty low. If it's the same objection to every request, and every request lists the same 8 objections, that's boilerplate. That's not particular to this one. If this request is objected to because it's overbroad as to the time period, and it is vague as to this phrase, that's a specific objection to that request. And that's not just gonna be automatically repeated. That's how I know it's specific in that boilerplate. And I wanted to echo something that Judge Gallo said earlier. So many disputes could be stopped before they arise if your response was clear to the other side as to whether you were withholding documents or not. Make whatever objections you're making. Notwithstanding these objections, we are producing X. But as Judge Gallo said, let the other side and the court know whether X is the total universe or whether X is a subset because you have withheld documents. If you're withholding documents based on the objection, make sure everybody knows. Any other questions?
What proportion of judges and magistrate judges in the Southern District would you say have local rules where they say, sure, we'll take phone calls about discovery disputes? And what proportion would actually be happy to take those?
How many of the magistrate judges in their local rules contemplate informal settlement conferences by phone? I think it's all of us.
I think Judge Denvin has, in his chamber's rules, it doesn't take phone calls and requires a motion up front. I think, but I think the rest of us,
Virtually all.
I think the rest of us welcome and want the phone call. So we know, as Judge Burkhardt mentioned earlier, so we have an idea what's coming down the pike.
And I will say that my general practice, I tend to be very available. And like Judge Gallo, I want to knock them out before paper has to be filed. I make myself very valuable up until the point where I feel, where I make a determination that the parties are overly reliant on me, that they're not trying, that they just as soon, rather than work with each other, just give it to Judge Burkhardt and let her decide. And once it gets to that point, you're gonna get a briefing schedule, it's gonna be 60 to 90 days before you get a decision on your discovery disputes because you have consumed more than your fair share of the judicial resources on the case.
There's a question in the back, but let me tell a very quick war story about this. In a case that I had maybe 4 years ago or so, where the parties were just bickering about everything. They couldn't agree if the sun was coming up in the east, and is that what the sun comes up?
It does.
Yes. Maybe that's why they couldn't agree. I'm not sure. But they couldn't agree on anything, and they were constantly calling in, and you know, I would ask them, have you met and confirmed? Yes, we have, in good faith, absolutely. But I never got the sense that they really were. I really didn't. Just because of the interpersonal relationships between the attorneys, they're just each other's throats about everything. It was very embarrassing for me just to witness this. So what I required at that point, and I've never done this since, and I've only done it that one time, but it seemed to work, is I said, okay, you now have to videotape your meet and confer process And I'm gonna watch it and see if you actually were genuinely trying to resolve your disputes. And so, I think I watched, I don't know, 6 or 7 hours of video. I'm serious. And every now and then they would take a break, and I know during the breaks they were out there going, we're not agreeing to anything. And then they get back on air, and then, oh yes, thank you, yeah, we're doing great. But it's really important. I can't tell you how important it is. I mean, litigation is tough enough as it is. And you can fight hard and be professional, but you don't have to be unreasonable and disagreeable when you're trying to resolve these disputes. And I think it really, we know this. We can see this when you're calling us up or we're having a discussion about your dispute. We can sense who's trying to really work through the dispute and trying to resolve it, and who is being the obstructionist and not trying to resolve it. We can tell by the tone of voice and the language that's being used. And we're human, and so that does have an effect on sometimes the ruling, because a lot of these disputes are really kind of down the middle, and it could go either way. Because I believe that if the disputes are really that far apart, that the parties really learn, they can find a way to resolve, and they know that this is a very unreasonable request, or the other side did everything they could to respond to it. They know that, but when it's closer to the middle, it's the subtle little things that are communicated to judges that are going to lean us in one direction or the other. And sometimes it's not always based on the law and the facts, because there's a lot of discretion involved in this. And we may just err on the side of the party that we think is trying to do their best to resolve the dispute in a reasonable, professional way.
Okay, we're out of time, so we should take our one last question.
Okay.
To go back to your instruction about responding to a request for production of documents and letting the other side and the court know that this is not the whole universe. I didn't hear the magic words privilege log, so I'm assuming you are willing to accept something less. How is that
Yes.
normally phrased? That, yes, we have documents, but we're not going to tell you what they are or how many we have.
Yeah, it doesn't have to be what they are or how many. But if you're standing on an objection, we are withholding documents based on our objection of X. Then they know that this is an objection they have to fight over or meet and confer on and figure out what your problem is and can that be narrowed. But if you send a response that doesn't make it clear, maybe you've given them everything and they just don't know it. So if you're withholding documents based on an objection, make it clear that you are. That's all.
Okay.
Not a discovery log. Thank you for your attention and your patience.
Thank you.
All right, I'd like to introduce our next panelist, John Morrill, who has worked in the Southern District of California for 28 years. He has held various positions in court operations, finance, and administration since joining the clerk's office in 1990. From 2005 to 2013, he served as Chief Deputy of Operations, and he was appointed by the court to serve as Clerk of the Court on April 29, 2014. During his presentation, Mr. Morrill will be discussing the top 10 things new lawyers should know about the clerk's office, resources available to attorneys at the clerk's office, and top tips for case management. Thank you for being here.
Good afternoon, everyone. I always love the afternoon session, but I smell strong coffee, so I think everyone will be alert. Thank you very much to the Federal Bar Association for the opportunity to speak with you today. One of my favorite duties as clerk of court is twice a year I get to swear in new attorneys, and maybe a few of you are here, but I know many of you have been practicing for a long time, but maybe federal litigation and federal court introduction is why you're here today. But I want to just welcome you all to the courthouse. We are in the jury assembly room right now. Most of my comments are going to focus on the first two areas that Morgan mentioned, kind of some top 10 maybe things to know about the services that the clerk's office provides, and also within that presentation a lot of very useful resources that are available to you from my office. After my presentation, you'll be hearing from a panel from Chambers, and they may be discussing a little more about case management and cases, and I'll touch upon a few things that also kind of interplay between the clerk's office and Chambers. So these top 10 items are really not listed in order of importance, but there's a little bit of a logical flow to them. But first of all, I think it's very important really to know where we are. The clerk's office, we've been, since I've worked here, in 3 different locations. At one time we were in the Schwartz Courthouse, then we were in the Federal Office Building, and now we're here in the Carter Keep Courthouse. So we're up on the 4th floor. That is our main office, our main intake area. Our business hours are 8:30 to 4:30. We always have staff at our intake windows, and they're available to come and answer questions if you have questions about filings. But we don't get a lot of visitors anymore with electronic filing. A lot of attorneys, of course, I'll talk a little more about e-filing, but we used to have lines out the door, and everyone, mostly couriers, would come and bring their filings, and that ended 12 years ago in 2006 when we adopted electronic case filing. But we are available to assist in person. You can also call us at our main telephone line, and there are also some email links that you can email staff as well in various different departments. So 4th floor of this building, we do have staff all over the courthouses. You're on a campus. This is the John Rhodes Federal Judicial Center. So the courthouse to the east of us here, the Schwartz Courthouse, we don't have clerk's office staff other than court reporters in that building. But in this building, it's really the majority of our staff, and the 4th floor is the main intake area. Resources, the most important one really I can point you to today is our website, as is casd.uscourts.gov, and that format is the same for every federal court. So Central District would be cacd.uscourts.gov. It is a great resource for attorneys who are new to federal court or just to learn about our specific court. Here online is where you can go to be admitted to court. Everything is done online with attorney admissions. Also CMECF for e-filing, you can link there from our site. CMECF stands for Case Management Electronic Case Filing. It's also where we post all of our announcements, and our general orders are all posted there, as well as local rules. So this is where, for example, every time a general order is filed, it's posted on our site. It is also where when we update local rules, those notices are also posted there. And we also post announcements about events like this. We work very closely in partnership with the Federal Bar Association for the events. Also, each judge has their own page on the website, and on that page it will have contacts for the judge's staff and also Chambers rules. And I think our law clerk panel will talk a little more about Chambers rules. Also, all our forms are available on the site, as well as the fee schedule and other contact information on how to reach us. It's a great resource. So as you probably know, you must be admitted to practice in the Southern District before filing documents or even before appearing in court. We will process your attorney admissions, and it is all done online now. You pay your fee online, a fee of $206. And if you haven't been admitted yet, I really strongly encourage you to do that. After you're admitted to practice, you should immediately register for CMECF, the electronic filing. Even if you don't think you're going to be filing documents in court anytime soon, you should still register for CMECF. There's no fee to register. And our attorney admissions clerk will help you and walk you through the process. There'll be a few emails going back and forth, but you can do it all online in at one time. It allows e-filing, but it also, you may be in on a case, your firm may be involved in a case, and you may be added to the case, but let's say you're not planning to file a document. Well, CMECF is also the way that you receive service of the document. So if you're not registered in the system, and there's a document that has to be served to your firm, you're gonna show as unregistered, and you're gonna have to wait to get it by mail while everyone else already got the filing by email, by e-service. So you really want to just get registered. The other benefit is we send out, and those of you who are registered know this, we use CMECF to send out a blast, note announcements about events or about local rule changes. And so if you're not registered, you're not getting these emails. So you really want to get those emails. We send, I think, typically on average, there's over 50,000 emails that are receiving these messages when we're sending these mass emails out. Things about applications for our Criminal Justice Act panel, applications for magistrate judge positions, all those things, we use the system for those notices. So important to get registered. E-filing is mandatory in this district. In some districts, it's optional, although nowadays pretty much most districts have mandated electronic filing. It's also available 24/7. So you can file documents late in the evening, early in the morning, on the weekend. Do be mindful though that sometimes in certain orders or chambers there may be time deadlines on certain filings, like at the close of business day, 5 p.m. But in general, the timeline goes right up to midnight in terms of the filing deadline. And here's another really important resource and something we provide. We provide training free of cost for lawyers and any of your support staff. And I think this is a great way for new attorneys or even attorneys who are just new to federal court to learn and ask questions. We have a training center, a training room here. It's hands-on. I have very experienced staff who have worked in our office and can answer questions, procedural questions, as well as technical questions, and they'll take as much time as you need. So there is a way to sign up for training through our website. There's a CMECF link, and it has all the resources there, and you could sign up for a class, and you could come back again as well. We don't, if you want to come back and get round 2, that's okay as well. The CMECF system, we have its own set of policies and procedures, and that is a really important document to have hand in hand with our local rules. It's essentially, these are the how-to when you're e-filing, and it's very important to review that. It goes over things like if you're filing, for example, a motion in a civil case with points and authorities, declarations, exhibits, etc. This manual will tell you how you should upload those to your system. You should file the motion, and then you should add as an attachment the points and authorities and your declarations. And so it's just certain kind of protocols that the court wants. And you want to follow those because our clerks are reviewing that and reviewing those, and as I'll mention later, they'll kind of get back with you, and if it's not filed correctly, you want the law clerk and the chambers who are reading them, you want them to receive it and format it in the way that it's supposed to be done. And it's just to your advantage. So the other resource that is an excellent resource is our toll-free helpline. We have a number during business hours that you can call, and it's 866-233-7983. You should take advantage of that. A human being will answer the phone, and they will walk you through the process, and it's most important to call that number before you file, so that we can get it right before it's submitted. So this is really another great resource for any attorney. It's also obviously be a great resource for legal assistants and paralegals, because many times they're going to be filing the documents for you. Just a couple things of what's in the administrative policies and procedures. We talk about, it lists and goes over things, documents that must be filed electronically. There is an exception in our district. Criminal sealed documents are still filed in paper the old-fashioned way. It goes through some procedures about service of documents as well, and how they're served electronically. Documents in the system, once they're uploaded, they're instantly served upon opposing counsel and on the court. There are some courtesy copy requirements for larger documents that the court asks that you provide a courtesy copy. But most of the time that's not necessary. Many times in filing a motion, you would also want to submit a proposed order, but we don't want that filed in the record. So you can email a proposed order to the court, and each judge has a general mailbox. It's called their e-file account. And you can send in a word processing, typically Word format, your proposed order after you file your motion. And then the court can take a look at that. They can use it if they want, but it's just a general practice. But it's important to just email those. You don't want to upload them on the docket like it's a filed document, because it is not. And then I mentioned a minute ago about problem documents. So sometimes what you'll notice is if you file something and maybe you didn't follow that procedure I outlined about attaching your points and authorities and your declaration, and sometimes you'll just get an email back. It's an officially formatted email from one of my staff that just says, you know, FYI, this has been accepted for filing, but in the future, you know, pursuant to this policy or procedure, file it this way next time. There will be other times, though, that maybe the filing just was not in compliance with the rules, and the court will enter what's called a discrepancy order, and it's essentially giving direction. It may reject the filing and direct you to refile it. So that's what that process is. My staff doesn't have authority to actually reject filings on our own. That is a judicial review, it's a judicial function. So we'll review it and submit it to the court and say, you know, we've noticed this deficiency, it doesn't follow the procedure, and then the court will enter that discrepancy order and just make sure to follow up and refile the document. Call us if you have questions. So we want to get the filing, we want to get it right, but that's kind of what that process is. Okay, getting outside the realm of filing documents, I wanted to share with you all that our courtrooms now all have the latest evidence presentation technology. So what this means is, in the old days, when you had a trial and you wanted to present evidence, and you would have to bring in your own AV specialist, your own document cameras, your own projectors, monitors, laptops, everything. Those days are gone. Every courtroom now, all 16 in the Schwartz Courthouse, and all 6 in this building, in the Carter Keep Courthouse, and our Central Courthouse, all have integrated evidence presentation technology. So what's important, though, is that you become familiar with that technology, because you don't want to come in and not be prepared. You want to be comfortable and familiar with the courtroom technology. So first thing I always recommend, and the judges always recommend this as well, is contact the judge's courtroom deputy prior to your hearing. So if it's an evidentiary hearing or a trial, that courtroom deputy's contact information is on our website under the judge's name. They'll allow a time for you to come in before your trial. And they'll actually, if they have time, they'll help you. How do you connect your computer to the podium? The podium has a document camera. There's also monitors at counsel tables, monitors at the witness stand, monitors in the jury box. So they'll familiarize you also how to control the control panel to switch sources. Maybe you want to show a video, now you want to show a photograph. But you want to be comfortable with that. We also do offer training sessions. We've offered several, and we're going to be scheduling some more in the future. To just come on in. It could be a Wednesday or a Friday afternoon, and you can sign up on our website as well. And that way you can just become comfortable with it if you're just interested in doing that. And I mentioned the courtroom deputy, and the role of the courtroom deputy from my staff is really critical. It's really a critical resource for you. That's the person that is really managing the judge's calendar. They are the one that may be calling you to ask about the status of your case in terms of if you have a hearing coming up, what's going to be happening, or are we going to be requesting continuance. But they're really an important person to get to know because they work so closely with their judge, and they're a great resource for you if you have questions about upcoming court proceedings. I also wanted to share with everyone information about accommodations that are available for you and your clients at the court. Back in the late 1990s, 1997, the court issued General Order 442A regarding services to persons with communications disabilities. And under that general order, the court will provide, whether it be sign language interpreters, assisted listening devices, or even real-time court reporters, to assist individuals who may be, during court proceedings, who may be hearing impaired or have other communications disabilities. And participants in court proceedings is defined as parties, jurors, attorneys, and witnesses. And so we've had situations before where parties needed that assistance. They contact our office, and our manager of interpreting services actually provides for whatever kind of service we need to provide, whether it's sign language interpreting. So please be aware of that service is available. We also have, we're one of the few courts, I think the only court in the Ninth Circuit, that actually has a nursing mother's room, both in this courthouse and in the Schwartz courthouse. That is available for attorneys, for your clients, for parties, for witnesses who may need to use those services. So through the General Services Administration, which owns the building, we have provided very nice facilities for that. And so we want to make sure everyone is aware of that resource that is available to you. Transcripts, we get a lot of questions about how do I get a transcript in my case. Each district judge has a court reporter assigned to her or to him, and you contact the court reporter directly. What you would want to do, though, is first go to the case docket and see which court reporter was covering that proceeding, because sometimes we do have different court reporters who are covering that day for a judge. And you see the name of the court reporter right in the minutes for the hearing. And then on our website, under our judges page or under our court reporter resources, you could just contact that court reporter directly to place an order. For hearings before the magistrate judge, you would just want to contact the courtroom deputy. We don't have court reporters in court before our magistrate judges. The courtroom deputies actually record all the proceedings, and then they'll arrange to get a transcript prepared for you. So that is who your resource would be for our hearing before a magistrate judge. And 10, we strive to be a user-friendly clerk's office. You'll often hear Chief Judge Moskowitz talk about we want to be a user-friendly court. And we also want to be a user-friendly clerk's office. So we're trying to provide as many opportunities to help with your filings and with your cases as much as we can. Just an overview of a few other just general things about the clerk's office. It is our responsibility to maintain the official records of the court. That is our main function, why clerks and clerks of court were established. We're also the custodian of public monies. So in civil litigation, this would be any monies in dispute would be deposited with the court in our court's registry. We safeguard those funds until the end of the case. We also, in criminal cases, we collect all the fines, penalties, forfeiture, restitution, those things. So we are the custodian of those public monies. We also are responsible for carrying out the court's jury management plan, and that involves creating the actual jury wheel from which we select citizens to participate in jury duty. We get our names from the voter registration list, and we summon jurors, and we assist the court with the whole jury process. So that is another function that we do here in our office. We provide all interpreting services, so in criminal proceedings, any individual who needs the assistance of an interpreter, we have actually one of the largest staff interpreting offices in the country. We have 13 Spanish language certified interpreters, and but we provide interpretation for all languages, and this mostly impacts criminal cases, but there are some occasions where in civil cases we would be assisting with interpreting services. We also conduct all the bill of cost hearings, something I would want to share. In civil cases, the court determines attorney's fees, but the clerk helps, and we hold a bill of cost hearing in cases essentially at the end of the case, the prevailing party would submit a bill of costs, and this would be costs such as fees, copy costs, costs for producing an exhibit used at trial. And so our staff will do an informal hearing. Sometimes it's just done on the pleadings, but we would do an informal hearing, and we would determine those costs based upon our local rules. And our website again, casd.uscourts.gov, I think is you'll find, as I mentioned earlier, really, I think answers to a lot of your questions about services to the court and services that we can provide here at the court. So I want to thank you all for giving me a few minutes to talk about some of the services we provide at the clerk's office, and look forward to seeing you around the courthouse. Thank you.
Sure, thank you for your patience. It's my pleasure now to introduce our next panel, which is the Judicial Law Clerks panel. Moana McMullan has been a career law clerk for District Judge Sabraw since 2003. And Paula Harrington has been a career law clerk for Magistrate Judge Crawford since 2012, when Judge Crawford joined the bench. Paula previously served as a career law clerk for Magistrate Judge Storms. Paula and Moana will discuss when it is appropriate to communicate with the court, legal writing tips for successful motion practice, including discovery motions and things to keep in mind when presenting discovery disputes to the court for resolution, and the different duties and responsibilities of magistrate judges and district judges. Thank you.
Good afternoon, everybody. My name is Moana McMullan. I'm a law clerk for Judge Sabraw, and I thought I'd just run through a few tips, pointers for things that you should and shouldn't do when you're communicating with the court, and offer maybe just some tips on legal writing, motion practice before the court. And I don't know what you've already learned or know about the differences between what the magistrate judges do and what the district judges do in this courthouse. The magistrate judges mostly work on non-dispositive motions, discovery issues. The district judges handle all dispositive motions, motions to dismiss, summary judgment motions, that sort of thing. So one piece of advice I would give you before calling the court is to know what it is that you're asking for. Do you have a discovery dispute? If you do, you should be calling the magistrate judge's chambers. You should not be calling the district judge's chambers. The other thing I would suggest that you do is to review the local rules and familiarize yourselves with them, and as well as the chambers rules that John Morrill mentioned a few minutes ago. A lot of the judges have chambers rules, rules specific to their own chambers, and they're all very different. In Judge Sabraw's chambers, for instance, we have, judge has a procedure for filing 12B motions, whereby you have to set up a telephonic conference with the court prior to filing any of those motions. I think that procedure is unique to him, and it's something that you should be aware of if you want to file a 12B motion, that some judges have unique procedures that they ask counsel to follow. The other thing I would mention is there are certain things that we can tell you as law clerks, and there are certain things that we cannot. A lot of people call us and ask us for legal advice, really, and we're not allowed to give out legal advice. We're happy to answer the procedural questions that you might have, but my co-clerk mentioned a story to me of someone calling and asking her, when is my responsive pleading due? That is not a procedural question. That is a question calling for legal advice. And as much as we would like to help you, we can't give you that. So make sure that you're calling us with procedural questions, not asking us for legal advice, because we're not allowed to give you that. The other thing my co-clerk asked me to mention was, we can't tell you when orders are going to be issued. Judge Sabraw, I know, does his best to get orders out as quickly as possible, but sometimes when that doesn't happen, attorneys get a little antsy and they want to know what's happening with their motions, and they'll call and they'll ask, do you know when that order might come out? You know when the judge might issue his order, and we can't tell you that. As much as you would like to know, we would appreciate if you don't call us and ask us when orders are going to be issued. Another thing I would mention in calling the court is the local rules forbid ex parte communications with the court. And basically what that means is calling the court and previewing your case to the court. And as an officer of the court and as a law clerk for a judge, attorneys are not really allowed to do that. So I guess when you're calling chambers, try to keep it really to the procedural questions. And if you have a dispute that you need the court to address, the best advice I can give you is to call in with your opposing counsel. Not a lot of attorneys do that, but we really appreciate those who do, because it really it follows the rule for no ex parte communication. Both parties are on the line. No one's previewing their case. Everyone's in on the conversation, and it's a lot more comfortable for us as law clerks. For me, I guess I'll just speak for me, but it's a lot more comfortable when you have everyone on the line and you have something that you want to bring to the attention to the court. So I would remind you of that local rule. And this is just kind of a matter of common sense, but I would also suggest that you really be kind to everyone that you talk to on the phone, whether it's the judge's judicial assistant or law clerk or the courtroom deputy or whoever it is. Whoever answers the phone, I would speak to like you're speaking to the judge, because we are his staff, and I think sometimes people forget that what you say to us is likely to go to the judge also. So just be mindful of that. The other thing I would mention is that is to be mindful of the court's time with your calls and your motions. I think that Judge Sabraw himself has about 600 cases, and 400 of those are criminal and 200 are civil. So in Judge Sabraw's chambers, Judge has a judicial assistant and he has two law clerks. So that means that myself and my co-clerk are responsible for 100 cases each. So just be mindful of that when you call the court in your motion filings. Be mindful of the court's time and make sure that you use that time wisely, and I think in a way that will best advance your case and best represent you before the court. And I know that we're getting short on time, so I'll let Paula go ahead.
Paula Harrington, I work for Magistrate Judge Crawford. So I was just going to go over kind of what in more detail what the magistrate judges do. They first get involved in the case after everybody files an answer. So we're usually watching the docket, and that cues us when all the answers are filed to set an early neutral evaluation conference. That's really just another name for a settlement conference. We try to, get as many cases as we can settled early on. The judge sets about 2.5 to 3 hours of time aside for those, and she'll have you come back if she thinks that it might settle the case. If the case doesn't settle, then she's going to set a schedule for your initial disclosures and your Rule 26 F meeting, and And then the next time we're going to talk to you is at a telephonic case management conference when she's going to set the dates from like your discovery cutoff and your up to through your pretrial conference. And we can generally talk to you about scheduling in those matters. So you can call us with questions about those things. Let's see. Usually, in the typical case, we set about 4 to 6 months for discovery, and a lot of times we'll get people asking us for a year or something like that. But it's just generally about 4 to 6 months. If there's a really good reason to give you more time, you need to put that in the judge is going to ask for a joint discovery statement from the parties before she talks to you at the CMC. And that's the time when you can explain if your case involves something that's going to take longer than 4 to 6 months, like maybe a lot of out-of-state depositions where you need discovery from, a foreign country or something like that. Let's see. So the other times that the magistrate judges get involved in the civil cases is when there's discovery disputes. And if you have a discovery dispute, you only have about 45 days from the time the dispute arises to bring it before the court. So that means you need to call your opposing counsel and satisfy the meet and confer requirements. And then the way we are resolving discovery disputes nowadays is with a joint motion process, and that requires you to cooperate with your opposing counsel and pass the document back and forth so that it's all presented to the court in one document. And the reason that we do that is it kind of eliminates a lot of the length of time that it takes to file the motion, the opposition, and then a reply. So it's just kind of all put in one document, and it's just a lot easier. Usually, if it's done correctly, it's a lot easier for us to consider a discovery dispute if it's in that format. A lot of times, we will get the discovery disputes they're typically unique to each case, but we do have some things that tend to get repeated. And so I thought I'd just give you a couple of examples where we will get, a lot of times we will get what I call the kitchen sink approach. We get like 300 pages of, briefing and exhibits and declarations, and a lot of those things are not cited in the joint motion, so we don't really even know why we have them. So if you're not citing something in your briefing, chances are we don't need the exhibit. And a lot of times it seems like the only thing that's missing is the thing that we need the most to resolve your discovery dispute. And a good example of that would be a declaration. So if you're trying to show, for example, that you shouldn't have to produce a big set of documents because it's not proportional to the case, you can't just argue that it isn't proportional. You have to really document that and tell us why. So you're going to need to get like an estimate of time or costs or whatever and explain the steps that you would need to take and why it wouldn't be a very good idea to require you to do all that because it's not that important to the case, and then you would need to explain why it's not all that important. And what we're trying to get people to do usually is, a lot of times people start with a really broad discovery request. They want everything from the beginning of time. And they're reluctant to narrow it. I guess they're afraid they're going to miss something. And so there's this big it's usually a dispute over, you're asking for too much. We can't go 10 years back, or we can't give you everything from, the time this person was born or whatever. So in your meet and confer, you want to try to narrow and tell us what you're willing, what it is you really need. Because we can't really do that for you. Let's see. So if you start with a really broad discovery request and you're in your meet and confer and you don't agree to narrow the scope of that, this is one of the things that we just deal with over and over again. You're not going to achieve the result that you're looking for. You're going to get something like this is something I've used over and over again. Particularly when a party stands on an overly broad request and does not make a reasonable attempt to narrow it or explain the need for such a broad range of documents and/or information, the court will not rewrite a party's discovery request to obtain the optimum result for that party. That is counsel's job. Nor will the court compel defendant as the responding party to provide further responses to any and all of plaintiff's overly broad discovery requests when it has already made a reasonable attempt to provide a substantive response to each request, along with an explanation as to why it believes the scope of documents and information provided are appropriate under the circumstances. So there was a lot of trouble to file that motion to get documents, and that party just really didn't get anything because they weren't really willing to dig in and explain what they really need. The other things we see a lot of is boilerplate objections. I'm not really sure where they came from, but there's kind of a set of them, and they're pretty useless. So a good thing to remember is that objections must be specific, clarified, explained, and supported. So if you're telling us that something is irrelevant or it's privileged or whatever, you can't just say those words. You have to explain why. Because we just kind of, if you just put a string of objections in there, we just kind of gloss over, and we're looking for the substance, for the real meat of what's going on with the dispute. And I guess that's kind of it for me. And I guess we're supposed to ask if you have any questions. Yes.
Is there like a typical timeline of how clerks and judges handle reading the briefs and making decisions? And then is there like a typical division of labor, like the clerks usually do this and the judges usually do that? I'm just thinking in terms of law in motion. For example, do you read the briefs when the outcome's in, and then you make a recommendation to the judge and the judge says yes or no? Or
well, if you're using the regular motion procedure, which is the motion, the opposition, and the reply, we generally are not going to look at it until we get the reply, till we have all the papers at one time. With the joint motion process, you're getting it all at one time. So as soon as it's filed, we try to do things in the order that they come in. So if I have several discovery disputes ahead of you, you might not get yours looked at right away. But we have everything. We should have everything we need as soon as it's filed. Does that answer your question?
Yeah, sort of. But then, like, is it the case that the law clerk reads everything and says to the judge, here's what I recommend, and the judge just says yes or no?
Well, I mean, I guess that wouldn't really work out very well just because, for the volume. So we have, sort of a basic format in mind, that we use, and we draft. We read all the papers. The law clerks read all the papers first. And then we draft it for a proposed order basically for the judge. And then the judge goes through it, and then you start a revision process if that's necessary. So that's usually the way it works. And then if we don't usually set a hearing on discovery matters, but if something comes up during that process where the judge and the law clerk are working together to try to get an order, then we would call you and set a hearing to have, you know, more argument or request more information or additional briefing or something like that.
Yes.
Just gonna be fast.
Okay.
Is there, I think you said that some judges have 2 law clerks. So will different motions on my case possibly be assigned to different clerks? Or will the same clerk always have all of the motions that might come on my case?
I think the judges handle it differently. In Judge Sabraw's chambers, he has 2 law clerks and a judicial assistant. We handle just primarily the civil cases, and we divide them by odd and even number. So if your case ends in an even number, it's going to be handled. I'm going to handle it, and an odd number my co-clerk will handle it, and we handle it from the beginning to the end. I don't know that other judges use that same system. You probably should ask the first time you call chambers, how do you divide up the cases? Some judges might do like 0 to 2 and 3 to 6, and some of the law clerks might be doing criminal matters. So I think the best thing to do is probably ask the first time that you call, how do you divide up the case? How do the law clerks divide up the caseload?
So on the magistrate judge's side, we have 2 law clerks usually, and I think most of the chambers do split it up odd and even. And so you're going to become familiar with a particular case. It's like not going to go back and forth. So it's all usually the same law clerk from the beginning to the end, except that we have some career law clerks, and then we have some clerks that are only here for a year. So at some point in your case, you might talk to a different law clerk.
Did you say on the magistrate side that there's some document in a discovery dispute that the 2 sides prepare in conjunction and bring?
Yes, it's called a joint motion.
Yeah.
And usually everything that we do in the magistrate chambers is usually by joint motion. So if you need an extension of the discovery cutoff, for example, you and your opposing counsel are going to get together and prepare this joint motion. And you could disagree about it. We just want it all in one document so that it's easier to look at. So if you disagree about it, or if you agree about it, whatever that is. And the discovery disputes, we do it the same way. And you're going to present your dispute on a document request or by request basis. So each document request or each interrogatory, if you have a dispute about that, you're going to have to justify it on a request by request basis in your joint motion as to why you don't think you got an adequate response and why the other party should be required to respond further.
I'm sorry, I think we're going to save a few questions just so we can let the final panel speak.
Okay.
Thank you so much. We just want to have enough time for our final panel, which it's my pleasure to introduce the district judges and our moderator. Judge Burns was appointed as a magistrate judge in 1997 and received his commission to serve as a district judge in 2003. And Judge Sabraw served as a Superior Court judge for the County of San Diego from 1998 to 2003 and received his commission to serve as a district judge in 2003. Carolina Bravo-Karimi, who is going to be moderating this panel, is the current FBA president and a partner at Wilson Turner Cosmo, the largest female-owned law firm here in San Diego. During their presentation, Judge Burns and Judge Sabraw will address top tips for new lawyers and the nuts and bolts of successful motion practice in federal court. Thank you for being here.
Well, thank you so much for being here. I have the pleasure of asking all the questions that you're always dying to know the answer to. And we have 2 very gracious judges that are willing to answer them for us today. So starting with Judge Burns, if you could just tell our attendees the top 2 things you think either young lawyers or lawyers that are new to the federal court should and should not do?
First thing you should do, I think, is take a very good look at your case, and when presenting it, you need to streamline it. You need to cut it down. Particularly if you get to the jury trial stage. My experience in both the criminal and civil cases is that they're invariably over-tried. Here's something to keep in mind. I've looked at this particularly in the last couple of years. There's a lot of research being done on brain physiology, brain science. The internet has affected our brains. And they have, no, it really has. They have not had definitive studies yet, but the attention spans are down. They're down. The average time a person's on an internet site is about 8 seconds before they click. There is this passion for more information, quick information. That all has implications for your presentation of a case, particularly in front of a jury. So I would say find a way to streamline your case. Every one of our judges, if a civil case goes to trial, sets time limits. I think that's still true. You do that still, right?
Yes.
And we surveyed all the judges. Everyone sets time limits. I don't play chess, never learned how to play it, but I found that a chess clock is a very useful device to have in court. And I set the time limits at the pretrial conference with the lawyers. When you're speaking, you're on the clock. The lawyers gnash their teeth about that. I've only had 2 lawyers in probably 50 civil jury trials that have hit the limit. One guy legitimately hit it, the other guy stalled on purpose and hit the limit. And then lost his case, went to the Ninth Circuit. One of the issues on appeal was that, Judge Burns had set this unreasonable time limit. He got to talk first. About 3 minutes into his monologue, Judge Kaczynski cut him off and said, you've been talking for 3 minutes and you haven't said anything. No wonder Judge Burns set a time limit. And of course, his case was affirmed. So that's one of the things. Find a way to shorten your case, shorten your presentation. The other bit of advice I give is it's always persuasive to me when somebody comes in and they concede that their position isn't without some weakness, whether that's in a jury trial or in a motion hearing. I used to tell the lawyers in the U.S. Attorney's Office when I was in a training position, find something to concede. Doesn't have to be the death knell for your case, but find something to concede. Think about that from a human nature standpoint. You're in a passionate argument with somebody over politics or something, and you make a slashing point, and they said, you're right, that's a good point, your immediate reaction is to kind of back off, cool your jets, right? Isn't that the way it works? Same phenomenon works in front of the people you're going to be presenting your cases to, whether judges or jurors. Immediately when somebody concedes something, you say, well, there's a certain earnestness to this person. They're at least conceding that it's not 100% their way. So those are the 2 bits of advice I would give. Shorten the presentation and look for something to concede.
Well, good afternoon. It's a pleasure to see all of you here. I'm really delighted to speak to, I think most of you are new practitioners, and it's really a nice setting to meet all of you. The 2 points I would make, I'd like to start maybe from a 30,000-foot perspective before getting into the weeds. And the 2 big things that I would offer, I had more than 2, but I'm limited to 2. The first one is preparation. So no matter what you do, whether it's a motion or you're in trial, I think preparation is the key. It is really the most important single ingredient in our profession. And what I have found is the best trial attorneys are the ones who are the most prepared. They may not have fancy law degrees, but preparation is the great equalizer. It's what allows an attorney to be spontaneous in the moment, maintain eye contact, cross-examine a witness in a real-time setting, and it's very persuasive, it's very powerful with jurors. And the only way you can do that is by being fully prepared. The lawyer who's able to examine a witness and then pinpoint the page and line reference on a deposition for impeachment and do it immediately. Be totally familiar with their, whatever you guys use, the to get the documents up in front of a jury. That's all preparation, and that spontaneity is so important, so vital. So I think that's the number one thing. Whatever you do, whatever it is, whether it's a memo, a motion, a trial, whatever, being fully prepared is so important. The second thing, I think, is to have a mentor. So one of my mentors on the bench is Judge Enright. And Judge Enright has this beautiful quote. He says, if you show me a man's idol, I'll show you the direction of his life. That is so true. And if you think about your own life experiences, the people that you model yourself after, whether it's a parent or another figure in your life, it really changes the way you behave and the way you approach things. So I had probably 4 mentors total, 2 when I was a lawyer, 2 when I was a judge. And when I was a young lawyer, I was like a human puppy. I would just follow my mentors around. I would button my jacket the same way they did. I would conduct myself in depositions or in law and motion or in trial the same way they did. And it's so important to do that because this is a very complicated profession that you've entered. There are so many moving parts, so many nuances, and you just cannot do them well unless you have a role model, a mentor, an experienced attorney who you have chemistry with, who you respect, and who you can learn from. So if you're not in a firm or a public interest setting like the DA's office or the public defender's office, then I would urge you to go to the county bar, seek out attorneys that you can shadow and emulate. Everyone is here to help if you ask, but I think having a mentor is absolutely critical.
So playing off of that a little, I think we can all agree that our reputation is everything, particularly in our legal community in San Diego, because it's somewhat smaller than some of the other legal communities in the state of California. Can you, starting with Judge Sabraw, give us some examples of how you believe an attorney's reputation either benefited or harmed his or her legal career?
Okay. All we have is our reputation. In this profession, reputation is everything. There are about 10,000 lawyers in the county bar. That sounds like a big number. It's not. There are 17 district judges. We meet every Monday, and we do talk about lawyers and how they behave, good and bad. Your reputation is key. What you say has to be your bond. There shouldn't need to be a confirming email or letter. What you say should be the be-all and the end-all. And so on the specific question of reputation and how it assists, I would use a positive example, and it comes from one of my first mentors, David Doyle, at Baker & McKenzie. I was a 4th-year lawyer, and I had a brand new client. It was a huge client, and I really wanted to win. And there was a big issue. It had to do, we were representing a hotel chain that was accused of paying one like HBO fee and then piping it into hundreds of rooms. You're not supposed to do that. You're supposed to pay for each room. Well, there was a smoking gun in our case. It was devastating. There was no way around it. And I have to confess, my first instinct as a young lawyer who wanted to earn this client's business was to figure out some way to bury the document. So I went to David Doyle and I said, you know, what do we do? And he said, is it privileged? Is there privacy? Is there some legitimate way not to produce? And the answer was no. And he said, well, then we have to produce it. And it added so much clarity. It was a bright line distinction between what is right and what is wrong, and just drawing a bright line. And then what we did, it was genius, and this is the idea of having a good mentor. We set it up for an E&E, a super early E&E, before Judge McHugh, who was a legendary figure. And we settled the case on a very reasonable basis. And in light of the settlement, we didn't have to produce that very damaging document ethically and properly. So there's always a way to do things. And so there's 2 points I would make out of that. One is having the mentor, learning that example. And 2, how just by that single act, from that point forward, I had nothing but the highest respect for David Doyle. And so anyone I talk to in the firm here today, 20-something years later, I speak about David Doyle and that example. Your reputation is everything, and it starts with each act.
Well, part of your question was, are we aware of situations where people have either helped themselves by reputation or hurt themselves? And I'm sure Dana is. I am. I'm a member of a couple of trial lawyer organizations in town. The American Board of Trial Advocates is a civil trial lawyers organization, and then the American College of Trial Attorneys is a both civil and criminal. Both of those organizations look first to competency. Has this person tried a lot of cases? Are they an able trial lawyer? But equally important is your reputation for ethics, for getting along, for being cooperative with counsel. And I've been involved in the vetting in both of those organizations, and we've had some superstar lawyers, people that get big verdicts and they're well known as trial lawyers, but they haven't been able to clear that second bar because they did something underhanded, or at least people think they did something underhanded years before. And the problem with a reputation like that is it sticks around. It's like the scent on a skunk. I mean, it's with you and it stays with you, and it's really, really hard to clear. So, all that to say, be very circumspect, particularly when you're confronted with a difficult issue like the one Dana talked about, and you're confronted with an issue like that. Think it through. Be deliberative about it. Don't rush to make a decision. And if you have misgivings, then I would follow the other advice he gave you about going to a mentor and saying, I don't know what I should do in this situation. What would your advice be? I know the bar has a hotline for certain ethical questions, and I would cover myself that way if I was really incisive about it. It takes a while to build a good reputation. It does. As Dana says, we have 10,000 lawyers here? Is that what it is? My goodness. So I remember when I was first thinking about being a lawyer in college in 1976, and a professor that cared about me called me and said, I don't think you should do this. And I said, well, why not? He said, look. And he had a book about this thick. He says, here's the attorney's directory. He says, look at all these lawyers. I don't know what the bar was then, probably fewer than 1,000 here. Now we have 10,000. It takes a while to build a good reputation, but you can wipe it out, in one instance. And word gets around. It's not just judges that chat. All of you know that you talk about each other, right? Talk about each other. You go in, have you ever had a case with so-and-so? Tell me, what can I expect? What about this person? And it's either good or it's bad, or I don't know them. But, usually, if anybody's had contact with a person, they have some opinion about it, which they're willing to share. So guard your reputation jealously. Reputation is the shadow cast daily by the way we conduct ourselves, and you should keep that in mind.
Obviously, the duty of candor probably plays into an attorney's reputation. For the newer folks in the room, Judge Burns, could you tell the group what is a duty of candor, and why does it matter so much to a federal judge?
Well, it's, as the name implies, it's a duty to be correct in things that you represent, to be sure. Again, this dovetails with what Dana was talking about preparation. Where you don't say something you're not certain about or make a representation. Let me tell you where I find that it manifests itself the most in what I do is in miscited cases. I'll get, briefing that says, oh, this case stands for this proposition, and you'll look at it and it doesn't stand for that proposition, or there's a clear delineation, there's a clear distinction between the situation at hand in that case, and yet somebody's trying to foist this on me. I don't know how many orders I do where I say, they're relying on these cases, and in 2 or 3 sentences or a paragraph, you can dismantle the reliance on that and say it's not apt here, it doesn't apply at all. A first-year law student who's taken the basic research class would know the distinctions and would have made them, and probably would have ruled it out, certainly wouldn't have put that answer on an exam. So that's, for me, that's where I see it the most. I see cases that either, I can't attribute it to a lack of analytical ability, because you pass the bar after all, right? You know how to do this, you know how to analyze cases, and say whether they, control the issue before you or not. So I have to assume that somebody's either sloppy, or they've relied on somebody that doesn't have analytical ability, or, the worst is that they're just trying to misrepresent something. And it doesn't help. Somebody comes into an oral argument like that, and that's usually the first question I'll put to them is, you cited this case, and really this case has nothing to do with it. What's your explanation for that?
Judge Sabraw, on a somewhat related note, social media is here, and it's here to stay. It's not going anywhere. Any tips on how attorneys should be mindful in their usage of social media?
Well, I'm not on it, so that would probably be my recommendation. I think it's an absolute, we are a profession, and we have to act accordingly. We are members of a select group, and I think behavior both inside the courthouse and outside needs to be uniform. We have an obligation to be professional. It doesn't mean that when you're on a social media site, particularly as an attorney, as an advocate, that you can't state positions, but I think you have to be prepared to stand by your comments 10 years down the road. You have to be able to live by what you say, and with social media it sticks, and it can be uncovered years down the road. So I think I would urge people to take the long view. I did that as a young lawyer before there was social media when I started, there were no computers, literally, and then emails came in, and I thought, with each email, I'm not going to send it unless 5 years from now I can read it and say I stand by that. I'm not going to be embarrassed by it. If it goes out in the newspaper, I can live by that. I think that's the way I would approach social media. There's a tendency to become so casual and so petty in today's environment, and I think that it's important to try to be civil and courteous in all settings. Social media would be no exception. And I guess just by example, it can really come back to haunt you. I had a case where there was something that an attorney said on some social media site that had to do with the case, and it was actually relevant and admissible, and it came in. And it was very damaging. So I just think you have to be mindful at all times.
Now I understand why he never replies to my political emails. I send him all these political emails, and I hear back from everybody else, but not him. Now I know why.
Now getting into a little bit more the nuts and bolts of practicing before district judges here in our district. Judge Burns, are there any particular resources that you would recommend attorneys use if they're wanting to become familiar with practicing in federal court?
I think most of us have chambers rules on the court website. I know I do, and I know it can be a pain in the neck because you've got, federal rules of civil procedure, and you have these general orders that you have to follow, and then a third set of rules can be vexing at times. I think most of us, I can speak for myself, have tried to shorten the number of rules and just fill gaps that are there, notwithstanding the federal rules and notwithstanding our general orders. So, for example, people want to know when things need to be filed with me. When do we have to have instructions filed? And that advice is on the website. But I've really tried to pare it down. Of course, we have a legal obligation not to have chambers rules that are inconsistent in any way with the federal rules or the general orders, and I think we all try to do that. Mine aren't really long. Sometimes, I've seen them not on our court, but other courts. And they go on for pages and pages, and I think, how can anybody keep all of this straight? So, but to answer your question, I think what I would do if I was confused at all, or just to have general familiarity with the court in which my case is pending, I would look at the website, say, are there any special rules here? Sometimes you can even get a feel for how the case is going to proceed by looking at the rules. Like, I have pretty ambitious, deadlines for things, and one looking at that would say, well, I got to get my stuff filed on time.
Judge Sabraw, any secondary resources that you might recommend, that you may recommend to interns or new law clerks?
Yes. I'm not sure if so I'm not pitching any particular product, but if I turn to my left in chambers, I have the Rudder series on civil evidence and trial, and then I have Wagstaffe on civil procedure before trial. Sources like that are so helpful. You just go right to them. It's amazing how almost any issue that comes up in trial or pre-trial is in those books. The other, probably the most important thing, I think, are jury instructions, pattern instructions. You've got to, if you have a negligence case, you should know what the elements are. So you should, that's obviously a very simple example, but the moment you file your case, it should be pled in accordance with facts that can prove and meet the elements of the case. And then you have to assume that when you're at trial, those are the instructions that will be read to the jury. That is the law. And you have to have the evidence to meet those elements. And so I think from day one, you've got to have, what are my claims? I'm assuming you're all civil litigators. What are the claims? What do I need to prove? I have my pattern instructions here. And I'm going to take my deposition knowing what those elements are, and I'm going to extract the evidence that way. Very important.
Hey, here's a follow-up on that too. If you want a special instruction, then draft it. I don't know how many times I get the motion in limine saying, well, we want a special instruction on this. And I said, okay, you want me to stay late? You want me to stay until 8 and try to work this out, or do you want to give me a draft and we can kind of tweak that to make it right? So if you want a special instruction, or you think one's necessary, not a standard pattern instruction, then propose that with the authority for it at the time you file your pretrial order, or at such time that the jury instructions are due.
So let's say, God forbid, you inadvertently miss a deadline. Or for some reason, unforeseen reason, you need a continuance. What should an attorney do to seek that continuance, or to be excused from missing the deadline?
One thing is to understand the culture of the court. Here, our court is a very collegial court relative to other federal courts. We meet every Monday. It's a court of team players, so we all help each other out, and I think that mindset permeates down through our law clerks, our staff, everyone. So it's a relatively informal federal court, as federal courts go. Some courts don't even allow, I think the Central District may still be this way, many of the judges don't allow attorneys to call into chambers and to talk to law clerks. Ours, by and large, it's judge by judge, but I think almost all judges permit that. So to answer this specific question, I think if you've blown a deadline, it's very important. The first thing you need to do is meet and confer. Contact your opposing counsel. If you have a professional relationship, in most of your cases you will. There are going to be exceptions where you just have a very difficult opposing counsel, but by and large, you're going to be able to call opposing counsel, talk about a deadline. If it's something like a statute of limitations or something, that's different. But if it's, I missed the filing, or I didn't do my interrogatory demand, I missed it by a day, or something like that. Start with a meet and confer, and oftentimes you can bring to the court a joint motion and order, which most judges will sign. I think you need just to be candid, to approach opposing counsel. If there's not agreement, then to contact the court and file your motion and seek relief, and be candid and honest as to why you need relief from that mistake.
I think one of the mistakes that judges sometimes make is they forget what it's like to be a lawyer. I certainly appeared in front of judges that didn't seem to have any clue of all the pressures and hassles and moving parts that come up when you're a lawyer. And I vowed that if I ever became a judge, I wouldn't do that. They have erasers on pencils because people make mistakes, right? So I'm usually pretty forgiving about it. I agree with Dana that you first seek excuse from opposing counsel. If it's inadvertent. I think the call of the question was, some emergency arises. Who's not going to recognize an emergency? I always do that. Now here's where it gets a little rougher. Deadlines and limits are not suggestions. They're deadlines and limits. There's a clear difference between those things. So I don't like it when it's just kind of casually ignored, and a couple of days before a hearing I'll get something like a stipulated continuance. There is no such thing over here. There's no stipulated continuance. And particularly if I've continued a case once already, or I found some good reason to postpone it at the request of the lawyers, or because something hasn't been filed, I'm not inclined to do it a second time. And I require a declaration with showing a true good cause, not just I was busy or this or that, but tell me why you didn't stay until 10 last week to get this done, knowing that it had been continued one time before. So I get a stingier if it's the second time in the same case or on the same motion.
So in the last 5 to 10 minutes, I wanted to shift gears a little bit to motion writing, because obviously that's a huge part of what lawyers do before both of you. Any tips on length, style, kind of the writing for a brief that you'd like to share?
I had dinner with Justice Chin just last month, and he said briefs are called briefs for a reason, and I thought that was pretty clever. That they should be brief, and so I think with Shakespeare who said brevity is the soul of wit. Briefs should be brief. What happens oftentimes, if you don't have time, you'll write a 25-page brief. If you have time and you put in the effort, it'll be a 15-page brief. That should be the goal. Obviously, with the pressures of litigation, that often cannot be accomplished. But I think the goal should be to be concise. With longer motions, an executive summary is really helpful. Tell us right at the beginning what it is you're asking and why you're entitled to it. Do it as persuasively as you can. I find the best written briefs are the reply brief, because the attorneys, it's a little contrary to what I just said, but the attorneys have not very much time, so they got to get right to the issue, and they have a 10-page limit. And the reply briefs are often the best. You just get right to it. On motions in limine for trial, what I do, even with complex cases, I have a significant patent trial starting in a couple of weeks. I've limited the attorneys to 5 motions in limine. The motions can be no more than 5 pages each, and the oppo no more than 5 pages, no reply. And what that does is the attorneys just get right to it. We know the evidence code. We don't need a summary of what evidence code 403 says. Just tell us what the evidence is and why it should be excluded. And I think that mindset, if you can employ it in all settings, can be very, very helpful. It's very refreshing when you get a brief that's really pithy, really short, and it's very, very persuasive.
Let me go back to where I started when I was asked to give you 2 tips. The first one was, shorten your case, manage your case, and that applies across the board, including the submissions, the motions that you file. The best writing I get is active voice. It gets to the point. The second thing I told you was about conceding something, and this is an area where you can make a concession. This case is not about these things. We're not contesting these issues. Here's where the battle lines are in this case. Boy, I sit up and take notice when I get something like that, because it really helps me crystallize what the case is about, what the issue is about. Again, this is coincidental. I just, before I came down today, I was working on motions in limine for a case next week. One lawyer went down and responded to the motions in limine by the other side. I said, agreed, this is not contested, agreed, this is not contested. Guess what? Got down to the one that he contested, and I looked at it with great interest, and I'm not going to tell you which way I'm going to rule, but I was very favorably impressed that this fellow wasn't throwing everything against the wall, that he made these concessions, and the one that he wanted to fight on had my rapt attention. The other thing I tell you is what you learn in your writing class. Like I said, active voice, contractions are great. I mean, we speak in contractions, don't we? I know Justice Scalia used to hate contractions and, forbade his law clerks from ever using them, but I think they're wonderful. So, don't be afraid to, tell it to me the way Laverne would put it to Shirley.
Any recommendations on what attorneys should do, if anything, to respond to derogatory remarks made by opposing counsel in either briefing or an oral argument?
Well, and that's going to happen. What I've found in litigation is by and large the vast majority of opposing counsel are professional and on the merits. But you run into attorneys that are extraordinarily difficult. It's as if they're working out their personality disorders in your very case. And when that happens, there's nothing you can do about it except not go down to that level. You have to litigate on the high road at all times in all settings. If you're being accused of something that's, because your reputation is everything, that is false, you have to counter it. And usually by declaration, but you can do it as a matter of fact. It can be short, it can simply state the contrary facts, but on the merits. As soon as lawyers start sniping, they lose their audience. I don't know who to believe when I have two ostensibly good lawyers from good law firms calling each other out by name. It's totally counterproductive, and I don't know who to believe, and it's a real big turnoff, frankly stated. And here's one last point on that. The biggest trials, bet the company cases with the best lawyers, invariably, and I've had many of these now, they're an absolute pleasure to preside over. The attorneys don't snipe at each other. They are professional, they are courteous. They go at each other with guns blazing on the merits, but it's never personal. And jurors love it, the court loves it, they get a great trial, it's fully litigated, and it's the most effective advocacy when you stay on the merits. Doesn't mean you're a shrinking violet. You can be very aggressive, but it's on the merits.
We have a distinguished lawyers memorial. It's over in the Superior Court, right? Don't you have a say in that? Who gets put on that every year when they pass away?
Yes.
Do I have it right? Distinguished Lawyers Memorial?
Criminal Justice Memorial.
Yeah. And I just got an email, maybe you did too, with the 6 new names that are going on there. Did anybody get that from the bar? And I read the little summary about them, and then I got interested in some of the other people that were on there, and I went and looked back. There was a lawyer named Bill Fletcher, who Dana knows, and I tried cases against. And his legacy on this was, even though he was a very zealous criminal defense lawyer, most of his friends were prosecutors and cops. And it talked about how he used to go out to the Colorado River with these people. He was a fellow that you could go into court with. I tried in a very serious cases, murder cases with him, and we, like a fine pair of scissors, I mean, we cut what came between us, but the blades would never do damage to one another. So, bear that in mind. The best way sometimes of dealing with somebody who's difficult or a name caller is to just sort of take it tongue in cheek, and that's hard to do. I mean, particularly if they're accusing you of some kind of dishonesty. But the old timers, I remember Peter Hughes, when he'd have a young prosecutor that's accusing things, he'd kind of put his head back and smile and laugh, and that completely, disarmed the whole thing. So, gauge your reaction. We're in an interesting time now. The President of the United States is at war with all the commentators on TV, and they're sniping back and forth. And I don't know about you, I don't know what to believe in these things that are being said. And so avoid getting into a situation like that in litigation. It's just not productive. It's frustrating.
We have a few more minutes. I wanted to open it up to see if anybody has any questions for either Judge Burns or Judge Sabraw.
How do you guys either feel about seeing young junior attorneys stand up in your courtroom?
Good one. I was just on an ABA panel that Koji Fukumura invited me to do. And you're probably aware the ABA is very active in encouraging judges, state and federal, to promote oral argument and trial and opportunities for new lawyers to present. And new lawyers, percentage-wise, can include many more women and people of color. Very important to address that segment and to give new lawyers the opportunity to present. So more and more judges now are doing things like Judge Alsup in the Northern District, where he might not have oral argument on a motion, but he will if the firm will commit to having a 5 or 7 year or younger attorney make the argument. More and more judges are doing that. The Eastern District, Judge Jack Weinstein is doing that. There are many examples. There are some, I think Judge Moskowitz in our court just went to that. I'm contemplating that. I know Judge Lucy Coe in the Northern District at the pretrial conference actually talks to the law firms about giving the younger lawyers an opportunity at trial. And so I don't think you should be afraid to ask either if the opportunity presents for the more senior lawyers, if there can be opportunities for young lawyers to present. It's important, and I think because of the diminishing number of trials and opportunities to present in court, we need to continue to provide avenues for young lawyers to present.
Any other questions?
Your Honors, you both use the term good firm. So what do you mean by good firm?
Well, I don't know what I mean by that. I came from a big law firm, so that was if I said that, I don't mean necessarily that they're good. I just I meant I was probably talking about big law generally. But to me, a good firm, can be a solo practitioner, can be a boutique firm, it can be a big law firm. Good to me just means you have experienced, ethical, credible, effective attorneys.
And the only thing I'd add to that is also a sense of collective responsibility. I had one unfortunate incident about 10 years ago with a lawyer that was kind of out of hand. Turned out they'd had other complaints about him. I did an unusual thing, which was to call over and talk to one of the senior partners. I wouldn't ordinarily do something like that, snitch on somebody, but what this fellow did was just so bad. And within a day or two, I think 3 of the senior partners they called and said, "Can we have an appointment with you?" And they came back, said, this guy's been trouble from the beginning. We made a mistake by hiring this guy, and we've had complaints from other lawyers and this and that. We're really sorry. We want to apologize. I think they later got rid of him, but it made me think, here's a group of very conscientious people that don't want to have somebody in the firm that is bringing down the reputation of the firm, and certainly didn't want me to think that they were unresponsive to this. So I would add that to at least my view of what a good firm is, one that takes responsibility collectively.
Well, thank you so much, Judge Burns and Judge Sabraw. We hope that you'll stay for the reception, and you can ask additional questions if you'd like. So a big round of applause.